First case for oral argument here this morning is under Rule 20, the City of Charlestown versus the Jefferson County Commission, docket number 19-0412, an appeal from the Circuit Court of Jefferson County. And I would like counsel to know that although Justice Workman is not here present in the courtroom today, she is viewing and listening to the oral argument, and she will be participating in the decision and opinion in this case. I'll remind you that each side has a total of 20 minutes to present your oral argument, and we do have a clock now right by the podium there that you can glance at and keep track of your own time. With that, counsel for the petitioner may proceed.
Before you do so, we'll just good morning and let you know that you can certainly, as you speak, remove your mic if you wish, or remove your mask if you wish to, and you don't have to, but if you'd like to. And we'll be asking questions, so we'll be removing our mics or our masks, and you have a mic cover there. So would ask once you're finished if you'll remove your mic cover and then use it again if you come back for rebuttal.
Okay.
So with that.
Thank you, Chief Justice. I'm Floyd M. Sayre III. I'm here on behalf of the City of Charlestown, West Virginia. We're appealing an order of summary judgment issued by the Circuit Court of Jefferson County. We had filed a deck action. West Virginia annexation was fairly stagnant up until about the 80s. There were a few cases dealing with the city of Morgantown and minor boundary adjustments, city of Beckley with annexation without elections. In the mid to late 80s, early 90s, there were some significant changes in annexation law. One, taking the density requirement out of the annexation without election, and two, placing much more restrictions on a minor boundary adjustment. Then we progressed up to 2009. In 2009, the legislature enacted a law, 864A, which allowed for specific annexation in areas that have an urban growth boundary. And the urban growth boundary is only allowed in counties that have countywide zoning. So only one county in the entire state that has countywide zoning. That is Jefferson County. So the three municipalities in Jefferson, or three of the municipalities in Jefferson County, working with the county commission, created urban boundaries. And in fact, in 2010, the county recognized the urban growth boundary for the city of Charlestown. That was reaffirmed as late as 2014 when the county, readopting their comprehensive plan, created the Jefferson 2035 plan, which showed this urban growth boundary. So when the legislature, recognizing these counties that have urban growth boundaries, created this new way of annexation, it allowed for annexation within these urban growth boundaries, but it took out the requirement for agreement of the county. In a minor boundary adjustment, the county has to make a determination if it's a minor boundary adjustment, and then has a hearing. In the without election, and I'm not even going to mention the annexation with election. That's really not part of this case, and I can't think of a city that has done it as an election annexation in my 30-plus years. I'm sure there may be some. Excuse me. But with the annexation without election, the county basically only had a ministerial duty. That was what the city of Beckley case stood for. And with the reduction of the density requirement, the appeal, if you were in that area, was to the circuit court. Now, what Judge Hammer has done, in my opinion, is that he has substituted his opinion dealing with annexation for what the legislature, the city, and the county had agreed to back as late as 2014. It makes no sense if you take the way he's interpreting that statute and saying that in the urban growth boundary, you have to comply with both the statute dealing with the annexation by minor boundary adjustment, which is that application, that the counties have all created. Plus, you have to then get a signed petition of all of the freeholders and voters in that area. Well, if you agree with that interpretation, the urban growth boundary is not a way for cities and counties to plan growth in the area. It's really a collar. It's a collar around the city of Charlestown, because every other city in the state would not have to do those two requirements. And I don't believe that's what the intent of the legislature was when they created 864A.
Let me ask you, Counsel,
Yes,
so
sir.
assuming an urban growth boundary and a minor boundary adjustment, do you believe under 864A or 864 or 865 there's any role for the public to express support for or opposition to the annexation? Or do you think they are completely cut off from having input either through an election, and you mentioned the election, but also the issue of their assent and getting the freeholders' statement of support for the adjustment?
I think that there is places for the individuals within those areas to put their input. I don't believe that there is.
What are those?
Well, at the beginning of the process, this all takes place at the city council meetings of the cities. And Charlestown, Shepherdstown, and Ranson are the only three cities that I believe affect this. And so there are open meetings that individuals can come and express their desires or oppositions at this time. There is an ordinance that's going to be passed that will then be presented to the county. The county then will have a public hearing. And I think that, at that point also the citizens have the ability for input into this process.
But all of the provisions set forth under 4A and 864 and 865, which do set forth processes for the landowner, the freeholders' assent and support for, you're saying those don't apply in this situation?
I think if there is substantial, in an annexation by minor boundary adjustment, it's basically been said that if there's substantial opposition, then there could be a defeating of that annexation. I think if there's substantial opposition and those individuals in the proposed area to be annexed, they still have the right to seek relief in the circuit court. I don't believe under what the legislature did under 864A, it gives the county commission the ability to step in and assert their decisions and authorities and deny the annexation.
My last question is the statutory updates from the legislature relating to 864 and 865. Obviously, some are more substantive than the others. Which statutory provisions, pre-2020 or post-2020, would apply here?
Well, at the time of the filing of this case, it'd be pre-2020, but I think that this is a deck action, so it doesn't do us any good to make a determination based on the law prior to February 2020. So I think that we would need to get now input based upon that 2020 statute that changed. And there were some pretty substantial changes in the minor boundary adjustment language, requiring the affidavits of businesses and freeholders and voters. But that still...
So you believe the 2020 amendments to 864 and 865 control here, or should control the outcome, and you believe that the changes were substantive and would impact the outcome of this, and therefore the case should go back?
I think the case should go back, yes, because I don't believe that Judge Hammer really answered the questions that needed to be answered. I think that now we need to look at what impact the new 2020 annexation laws have on that urban growth boundary. I'm not so sure that those changes in and of themselves, I guess when a petition is filed, then we need to look at what a petition for annexation, not a petition for appeal. We need to apply all those new statutes to what we're doing now. I don't think we can go back. And I think that's one of the things a little confusing maybe, because when I look at the county's response, they're litigating a petition for annexation that was turned down. The city of Charlestown did not appeal that. We're not litigating that specific petition for annexation. It was turned down. We're not trying to go back and breathe life into it. We just want to know what we can do and how we can annex under this urban growth boundary. That's what we're asking the court to help us with. And I think that sending it back to Judge Hammer is probably the most reasonable way, though I guess if I was asking for the stars, I would ask that you reverse it and find how we did in the petition, that we have the right to annex it without them having any ability to say no.
Well, the new statute says, as I understand it, that if it's a minor boundary adjustment within your urban growth area, and you comply with 864 and 865, then the county commission has no right to contest.
That's correct. They don't have the right to substitute their opinion into the annexation process.
But you still have to comply with 864 and 865.
Depending upon which type of annexation that you do, that's correct.
Okay. Thank you.
Just to clarify then, you're saying that based on the fact that you filed a deck action now, that you pretty much conceded that what's taken place up to this point, would you have to start over basically the process depending on how this action is resolved? Is that what you're saying, or are you saying you're wanting this court to send it back and determine if what you've already done was correct?
No, we're not asking for this court to determine what took place with that prior petition for annexation under the urban boundary or urban growth boundary. I don't think we have the ability to appeal that. The statute's pretty clear on how you appeal a decision from the circuit court, and we did not appeal it. The city of Charlestown, they don't want to be necessarily adverse to the county. They didn't want to, but that we want to know what our rights are under this statute. And yes, there has been a change now. This was a 2019 matter, and the statutes have now changed effective, I think, of February of 2020. So no matter what we wanted to do, we now have to comply with the 2020 statutes.
All right.
Thank you.
Thank you.
Take your...
Oh, sorry about that.
Well, all right. May it please the court. I'm Nathan Cochran, Assistant Prosecutor, Jefferson County. I serve, in effect, as the General Counsel for the County Commission under authority of the prosecutor. What do we know about this case so far? Well, we know, one, that the County Commission's decision to reject the annexation was final, and that became really apparent when the city filed their reply brief in this case, and they said on page 2 that they were only seeking guidance, and they acknowledged that the decision was final. That's one thing. Number 2, we know that the statute has been amended, as you all have said, and I believe that the amendments were done in direct response to this case. I know that Senator Rucker from our area was one of the principal forces behind that statute getting amended. I think we know that the amendment clarifies the legislative intent. It was the County Commission's position that, as you know, when you're reading through the brief and you read through the statutes, under the 4A provision, and we're talking about 4AC2. I'll just refer to it as 4A to make it easier. But under the 4AC2 provision, it says that the city can annex this property if they follow Section 4 and Section 5. Now, that's a little confusing, but when you take a step back and think about the big picture, it's really not. Every one of these annexation provisions provide an ability to protect citizens' rights. They're mostly generated by citizens either filing a petition in Section 2 and getting an election going, or in Section 4, the landowner of the affected area actually filing the petition. Or in Section 5, under the former Section 5, the minor boundary adjustment, that is where it says that, the city can start it, but it gives a whole bunch of procedural steps in a normal minor boundary adjustment that the commission looks at all kinds of factors, and the commission has the ability to agree or disagree with the annexation. Again, protecting citizens' rights. In this case, the city just foisted this annexation on the citizens, and that's what the commission objected to. And the commission believed, and still does believe, that because the 4A section says you have to comply with Section 4, which the city didn't even address, and Section 5, except the county doesn't have to agree, the county believed that that incorporated and made that part of the statute a threshold requirement that the county had to address under Section 5. And that's why the county turned this annexation down, because the city did not meet the threshold requirements. We called it in the brief a gatekeeping function. You know, I don't care what we call it, but it's essentially the failure of the city to meet the threshold requirements, which we believe include having addressed the citizens' concerns by the petition in Section 4 and the Section 5 section. Under the Section 4, the landowner starts it. I mean, really what Section 4A was designed to do was to protect those landowner rights, because what happens is the landowner has a piece of property and says, hey, I want to become a part of the city of Ranson or Charlestown. And then they file a petition and they ask the city to annex them. And then the city responds and says, sure, we'll annex you. And then they do an ordinance, and then take it to the county commission. And if they do all that right, it is a ministerial act on the part of the county commission. In this case, they didn't do it right because they didn't address Chapter 4. So we know that the amendment clarifies the legislative intent, because the new amendment specifically includes, if you're going to go under the 2020 amendment for a minor boundary adjustment, it specifically includes evidence of citizens' consent. They send out affidavits. The citizens can return those affidavits, complain, that kind of thing. So even in a minor boundary adjustment, it protects the citizens' rights. And I think that that evidences the intent of the legislature, that the whole concept of the citizens being able to comment is part of the threshold requirement.
Do you agree with the petitioner who, I don't want to put words in his mouth, but I think he essentially conceded that the 2020 statute applies? Do you agree with that?
Well, it appears to me, ma'am, that the whole paradigm has shifted now, and the former case is dead. Not only because, well, primarily because they chose to not appeal the county commission's decision within the time frame, but also because they have conceded that they're not trying to appeal the case in this sense. So I think they have to go back and start over. In answer to your question, Justice, the what has been done to this point is dead, and the 2020 statute would apply, because they have to start over.
So this is a declaratory action, and so we're trying to, essentially what the city wants us to do is say, how do we do it right? And if I look, and as I look at the statutes, and I want to make sure I'm not misunderstanding this.
Yes, sir.
864 is a method whereby the individuals in an area can seek to be annexed, and they're asking the city to, or the city to take them in. 865 is a method whereby the city says, we want to take in this area by minor boundary adjustment, and they can do that without an election if they have a majority of the freeholders and the people that have businesses and that sort of stuff in. So it would be impossible to comply with both statutes. It's either one or the other. 4A tells you what you got to do, and then 4 says this is how individual freeholders in that area can petition to be annexed. And 5 says this is how the city does it. Am I reading that correctly?
I don't think it's impossible, but what I think happens in under 4A is that it's directing you back to Chapter 4, which is the citizens asking to be annexed. How all this got started, I think, was the Eastern Panhandle experienced a tremendous amount of growth in the early 2000s, just, the building boom. The county commission at that time was very anti-growth. And the statute was amended to give citizens who wanted to go to the city and say, hey, we want to have a housing development. The county commission doesn't want to let us do that. We want to get annexed into the city, so that way you all may agree to let us have a subdivision. And that's really how all this got started. And that's why it was an attempt to fix that that issue in the boom. Now, the county commission today in Jefferson County is very different. They're much more pro-growth. But I think that's where it came from. And I hope I've addressed your question, Judge. If not, you can stop me. But one of the other things that I think that we know is that the Jefferson County Commission has approved various minor boundary adjustment annexations since the time of this case. My brief references one in Shepherdstown. Actually, the city did one not long ago. So, again, in answer to your case, I think they already know how to do it. And how you do it is you go and you file this petition from the landowners asking to be annexed, and then you just follow the procedural steps there. You don't just randomly go out and say, hey, we're going to annex 2,600 acres on our own and get...
Well, doesn't Section 5 say they can do that if they can get the freeholders in that 2,600 acres, or a majority of the freeholders in that 2,600 acres, to file an affidavit saying, yeah, we agree?
Sure. And that's the beauty of it, is the people who live there have to want it.
Well, I don't have any problem with it, but Section 4 essentially said, if you look at Section 4, it would be the majority of the freeholders in that 2,600 acres coming to the city saying, we want to file a petition for annexation, and here we're all joining this petition. So it's either 4 or it's 5. It's not both. Right? Am I missing the point here?
Well, 5 says, 5 essentially essentially says that the city files this annexation, and what really happened in 5, the major change was 5 said that the county has to determine whether they meet the threshold requirements, and the threshold requirements include the folks in the affected area being sent this affidavit and not objecting to the annexation.
Right, and it also provides in Section 5, for example, tells them how they have to get notice to the folks, and it puts a burden. It's kind of like in bankruptcy court, it's a reverse notice kind of thing. If they follow the appropriate procedure in sending notice and there is no objection, they're deemed to agree. Is that right?
I believe that's correct.
So it's a different process than in 4.
But it does give them the opportunity
Don't
to
have
do
a problem with that. I don't have a problem with that. But my point is, I think that you can't necessarily, I guess you could, but the city has a right to say we want to take this property in, and then they get to try and get the affidavits of consent. But that doesn't require the folks in that area under under Article 4 to file their own petition, does it?
It may not under the new statute.
Right. Okay.
Although under 4A it does.
I think. Well, under 4A, I kind of disagree with you a little bit. I guess we'll agree to disagree on that
All right.
point. You can't. I think it's not impossible to happen, but I think 5 gives the city the right to try and do it and get the consent rather than requiring the individual citizens to file the petition. So.
And yes, sir. Although under 4A it still says if you got to follow Section 4 and Section 5. So whether that makes it an unresolvable dilemma, that's up to this court. But all of the annexation statutes provide for folks to have citizen input. And what I think the legislature attempted to do in 4A was when they said the county doesn't have to agree, they reinserted something there to have citizen input into the equation. Let me just say a couple of things about my cross-assignment of error, and I will quit. I believe that the court reached the right decision below. I think that the court's determination that the section of Chapter 5, Section D, where it required the county commission to determine threshold requirements was an agreement. I think that was in error because that's not an agreement. The agreement in Chapter 5 was after having all the criteria, all the elements placed before the county commission could agree or not agree to the annexation in a normal minor boundary adjustment, not in an urban growth boundary. The other thing is,
I'm a little confused just on this, just from a procedural standpoint. Help me figure this out. You are asserting cross assignments of error, but you believe that the circuit court got it right. So does that...
In the ultimate decision, they did, because what they ultimately decided was that the fact that the city ignored and didn't even address Chapter 4, whenever you're in that section in 4A that says you have to follow Chapter 4, or I'm sorry, Section 4 and Section 5, the city didn't even have any kind of petition or any input from citizens wanting to be annexed. And that's what the circuit judge said. He said this is basically a violation of these citizens' ability to participate, and it was the wrong application of Chapter 4. And so that's what he got right. But in doing that, what he not so much error, but he just didn't clearly address it was the part about the threshold requirements being an agreement, and the second part being the county commission made an independent determination, which is part of their legislative function, that the 2,600 acres was not minor. And the case law has basically left it to the county commissions to determine what is a minor boundary adjustment. And in this case, this doubled the size of Charlestown, basically a couple thousand people involved, businesses. The county commission did not agree that it was a minor boundary adjustment. And so that was the other issue that the county...
But asserting that cross-assignment error sort of undercuts your argument that you're not, it is not proper to ask us to consider the underlying decision of the commission, which was not appealed, right?
That's right. Well, it's in the time that you're filing a reply brief, I asserted those cross assignments of error because I believe that the court was incorrect on that issue. But I believe he was correct generally on the whole concept that the city ignored the citizens' petition required by Chapter 4 or Section 4. Anything else?
So just to clarify, following up on Justice Walker's question, so are you asking this to be sent back
No.
for a determination, or do you believe...
I am not.
So will you believe he was incorrect, but not incorrect enough to change it? Is that accurate? Is that...
I believe that the case below is dead.
Okay.
And I kind of wonder why that we're here. But that, because is it moot? I mean, that's a question that you all have to decide.
All right. Thank you.
Thank you.
Again, this case is not dead. The annexation, the attempted annexation of the city of Charlestown is the case, I believe, when he keeps referring to it as dead. That's not here. Justice Hutchison, I think you're correct. You cannot comply with 4 and 5. I think that the legislature, one of the differences in 4 and 5 is that in Section 4 it requires an ordinance, which is an action that the city has to take. In Section 5, it doesn't require the ordinance. So I think that you have to have an ordinance to get it on the record and get it up to the county commission. Yes, Senator Rucker was the lead sponsor in the 2020 law change. If she wanted to do away with annexations and urban growth boundaries, she could have just as easily had that section repealed. That section wasn't repealed, so that section is still there. We think that this case is ripe for reversal, that the Judge Hammer substituted his opinion to what the legislature had set out. But one last thing, as far as the actual signed petitions, individuals have always had the right to appear at the public hearings. These have public hearings and express their either for or against it. So there is always been input in these. In these cases, there's input at least on 2 occasions, one in front of the city and one in front of the county. So based upon the petitions and the arguments today, we would ask that this matter be reversed. Thank you.
All right. Thank you. The case will be submitted.
Nice to be able to be in court without having to look at a rule.
It's good to see you.
We're very glad that you all were able to join us. We also enjoy being in person.
You all take care. Thank you.
Have a good one, guys.
Safe travels, gentlemen.
Drive carefully going back northeast.
Chief Counsel is here. They're going to be coming in.
It's a screwed up statute.
The next case for oral argument is also being presented under Rule 20, In Re PF, docket number 20-0113. Counsel may come up to the table. This is an appeal from the Circuit Court of Logan County, West Virginia. And although Justice Workman is not here present in the courtroom right now, she is viewing and listening to the oral argument, and she will be participating in the decision and opinion in this case. I'll remind counsel that you each have 20 minutes per side to present your oral argument, and there is a clock right beside the podium now so that you can monitor your time. And with that, counsel for the petitioner may proceed.
And I would just inform you, the court, because we have petitions here between us, we have removed our masks, so we'll be able to ask questions, and you may certainly remove your mask if you wish to. You may not. You don't have to if you'd rather leave it on. But if you'd like to remove it while you're addressing the court, that's perfectly fine.
Thank you, Your Honor. May it please the court, my name is Maggie Cool, and I represent the petitioner in this matter. As this is a confidential case, I am not going to refer to her by name, but I will just refer to her as grandmother throughout my presentation. This is an abuse and neglect case wherein the department took custody of the child at the onset of the case. This is a maternal grandmother who contacted the department and expressed her desire to have custody of the child. They had placed the child with a foster family, and they continued to leave the child with the foster family, but they did order a home study be conducted upon the grandmother, which was approved. For a while, grandmother had some visitation, and keep in mind at this point she had no counsel, and she has never been an actual party to this case. So she had visitation for a while, but then shortly after the home study was approved, they stopped her visitation with the child. She was unsure why. She was then very concerned about the status of the case because she knew that her daughter, who was the respondent mother, had a very serious drug issue, and she was very concerned that this case was going to lead to a termination of the parental rights and that this child would end up adopted. So she retained myself to file a motion to intervene and ask for custody of the child, which I did, and we were denied. And it is the order denying that we are appealing. That order was entered in January 7th of 2020. As the court is well aware, the West Virginia legislature has recognized the importance of the grandparent-grandchild relationship and the bond thereof, and they have adopted, of course, 49.4.114.3A3, sorry, I'm getting a little tongue-tied, which gives a grandparent preference. It states, for purposes of placement for a child for adoption by the department shall first consider the suitability and willingness of any known grandparent or grandparents to adopt the child. It goes on and later states, it shall assure that the grandparents are offered the placement of the child prior to the consideration of any other prospective adoptive parents. Now I know what everyone's thinking. Everyone heard the word adoption in there, and everyone's saying, well, this applies when we get to the point that the child's adopted. That, of course, is how most courts see it. That is what the state and the guardian ad litem are going to argue. They're going to say at the time that we tried to intervene and ask for custody, that they were just at the adjudication stage, and therefore we did this way too soon, and this only applies when they're looking at adoption. However, the problem with that is that when we wait until this child is adoptable before we look at the grandparents for placement, it results in an interpretation where we are disregarding the grandparent preference, and I will explain that. When a child is taken into custody by the department right then, when they file that petition, they have to figure out, where are we going with this case? Where do we want to go with this case? And they have the option of reunification. Is that going to be on the table? And with any reunification plan, there's the contingency backup plan, the concurrent plan of adoption if reunification fails. And we know that sadly, more often than not, these reunifications fail. So they're either looking at reunification with a concurrent plan for adoption, or they are looking at, we're going to terminate rights and put the child up for adoption. Occasionally, we'll have a circumstance where rather than adoption, they're just looking at guardianship. But most often, it's either the two that I have referenced. So when they take this child into custody and they put the child with a family, occasionally those are temporary placements. But we all know that a child's not supposed to be bounced back and forth from a number of different placements. And you all have held that on a number of occasions. I think you all addressed that in James versus Maynard, where you talked about it being traumatic to move a child back and forth a lot. So they're trying to, early on in the case, find a stable home that in the event that this child becomes adoptable, the child can be adopted by that family. Well, if the grandparent is supposed to be first in line for adoption, then they should be first in line for placement, so that the child doesn't get moved back and forth. Because what happens in these cases is that you put a child with a foster family, ignoring the grandparent, you put a child with a foster family, and this case takes 6 months, 9 months, a year before the child's adoptable. This child is now bonded with the foster family, and it's typically not in the child's best interest, which is the polar star of all these cases. It's typically not in the child's best interest at that point to take the child from the foster parent and place the child with a suitable grandparent. So the preference gets completely ignored. And sometimes rightfully so. I know the court addressed this earlier this year, and you all had a decision, a memorandum decision that came out in June 15th of 2020 regarding a grandfather. I believe the case was in Ray JP, and it was a grandfather who was, whose home study was delayed because of mistakes by the department. And so then when it came down to the child being at the adoptable stage, the circuit courts had an evidentiary hearing and determined that it was not in the child's best interest for the child now to be with the appropriate grandparent, but to stay with the foster family. And I know that the majority of the court sent that back, although Justice Hutchinson dissented in that case, and rightfully so, because he was talking about the polar star of the child. But that's why, if we're going to do what's in the best interest of the child, we need to address this preference at the beginning of the case and put the child with an appropriate grandparent where those are prior to the child being adopted. Otherwise, we're not given the full extent to this statute. It is being disregarded and ignored.
If I could ask you just on that point, it's a little bit unclear from the record to me what type of a home study, if any, was actually done. And can you elaborate on that? Or did you believe that the home study was inadequate, or
No.
not done at the right time, or what is your position on that?
I actually believe they did the home study at the right time. The home study was done well before I was in the matter. So the home study was done pretty much right off the bat. I believe that I got in this case this time last year. I don't know exactly when the petition was filed because I don't have access to the petition, but I believe it was maybe May of that year. So my client had an approved home study when she came to my office. So I have no qualms with the home study whatsoever. My issue is that she had an approved home study. She also had already taken all the PRIDE training classes as a foster parent, and had a number of other requirements that she had already met, showing that she was a suitable placement for the child, that she was an appropriate grandparent for this child. And
But haven't the circumstances of her home changed in terms of her ability to pass a home study now?
Honestly, Your Honor, I don't know that. I know that the guardian ad litem alleged that, but any of the things that she alleged, if they are true, occurred after this was already denied. And we never had a hearing to address anything in the home study or to address her suitability. There wasn't an evidentiary hearing in this matter to address those things.
So the allegations are that your client's husband returned from the penitentiary to the home.
My client has told me that her husband does not live in that home, although, again, I believe that occurred after this order that we appealed was denied on January 7th. I believe that occurred in February, from what my client has told me. She said he has a separate home. He doesn't actually live in her home. And again, there's never been a hearing in this matter to address any of those allegations that the guardian ad litem raised.
Counsel, and I appreciate your description of kind of what is a workable process and the sequence of the timing. At the outset, you identified 49-4-114, the grandparent preference, is the basis upon which you believe that the grandmother had the right to intervene. I want to make sure I hear, because candidly the brief was pretty sparse, no citation to any cases or other statutory basis to justify intervening. Other than 49-4-114 that you've mentioned here, what case law and what other statutory provisions should this court look to as the basis for the right to intervene?
I don't know that there's case law on point. My argument would be this, that the statute on intervention, which is 49-4-601H, it goes through and it says custodian. Well, no, she wasn't a custodian. It talks about having parental rights. Nope, she didn't have any parental rights. It mentions foster parents. Well, she's not a foster parent. It says relative caregiver. She wasn't a relative caregiver. And it says pre-adoptive parents. That's where I think a grandparent, if a grandparent has an approved home study and would be a suitable grandparent, appropriate grandparent for placement for adoption, would they not be a pre-adoptive parent? They're supposed to be first in line.
Well, that's where I was, wanted to try to smoke out where else other than 114, and you've gone to 601. And I appreciate the fact that you've identified your belief that she does not fall within several of those categories and what category you do believe. So you're pointing us to the pre-adoptive, and it's really for us then to say, do we think that she has should be given the meaningful opportunity, and does she fit the definition, what's contemplated under a pre-adoptive parent?
Correct, Your Honor. And bringing up the meaningful opportunity, as the court is aware from the statute, there is a presumption that placement with the grandparent is in the child's best interest. And I understand that's not absolute. The court has said that on a number of occasions. That's not an absolute. But that's something that the state would have to rebut. And where is our evidentiary hearing where they rebutted the presumption that she was in the best interest of the child, the best placement for the child? We haven't had a hearing to rebut that, as I've already pointed out. So I don't know how the state gets past the presumption that it's in the best interest of the child for be with the grandmother without that. So this court has repeatedly emphasized the importance of the grandparent-grandchild relationship. I think you all had said, actually I know you all had said, you talked about an unbreakable link from heredity that's between a grandchild and a grandparent. And what the Circuit Court of Logan County had before them was a grandmother who was fit to care for the grandchild, who was willing to take care of the grandchild. She was willing to adopt the child if that's what, if the child ever became adoptable. She acknowledged the problems with her own child. That's why she was so concerned about getting her foot in the door, because she feared and she suspected that her daughter's parental rights would be terminated, and she wanted to make sure the court was aware that she was there and ready to take custody of the child. So under those circumstances, it's presumed that it's in the best interest of the child to be with this grandparent, with my client. But that best interest was disregarded, the grandparent preference was disregarded, and our motion was denied, and I believe that was an error.
Are you aware of any evidence or any proceeding where placement with the grandparent was in fact even discussed by the court, or why the child was not placed with the grandparent?
No, Your Honor, I am not. I was allowed very briefly to go into the courtroom on that October date, where the judge told me that we basically filed this premature because they were only at the adjudication stage. I was at the court waiting outside the courtroom on January 7th when they were supposed to be having a disposition hearing. I was not allowed entry, obviously, because I was not considered a party and it is a confidential proceeding. The only information that I received after that hearing, of course, was the order denying our motion and rumor that they didn't actually have a disposition hearing that day. And then that's all I have. That's all I know. If they had a hearing talking about why she's not appropriate, we were not invited to that hearing and we were not allowed access to the court.
So you don't know, and your client has never been informed as to why the child was not placed with her?
The department would not speak to me. I've had very few, very minor, simple conversations with the guardian ad litem because they would not share information with me. My client has not shared with me that they have told her out of my presence why she does not have the child. I cannot tell you for certain that someone hasn't said something to her off the record, but she has not shared that with me.
All right, thank you.
All right.
All right.
Thank you.
Thank you.
But, can I ask one further?
Certainly.
Counsel,
Certainly.
one additional question. I apologize, and I probably could save it to rebuttal, but I think it's important understanding the issue between the right to intervene and the issue of the custody. Looking at the order from the court, how is the custody issue actually before us versus the ruling of the court relating to the denial of the motion to intervene?
That was a combined motion. I mean, the purpose of our motion to intervene was to ask for custody. That was...
But the order from the court just denied the motion to intervene. Isn't the custody issue kind of separate and distinct?
Well, you would think so, but if we're not allowed to participate in any of the hearings, then there's no way for us to advocate for the custody of the child.
But am I right in that the order denying the motion to intervene made no reference, no comment relating to the custody issue?
That's correct.
Thank you.
You may proceed.
Mr. Chief Justice, and may it please the court, John Maslin on behalf of the West Virginia Department of Health and Human Resources. Because this court has jurisdiction to hear this appeal, and because the circuit court did not abuse its discretion in denying grandmother's motion to intervene, this court should affirm. First, on jurisdiction. The order denying the motion to intervene is a final appealable order. This court held so in St. Mary's Medical Center versus Steele of West Virginia. Because the order kept grandmother out of court, she could not move for custody, to answer Justice Jenkins's question, and that is why the court did not address that, because it denied the motion to intervene. The citation to St. Mary's Medical Center is 240 West Virginia, 238, page 241, footnote 2. This also addresses the concern that Justice Hutchinson raised 13 days ago in W.Va with respect to the ability of this court to review decisions by the circuit courts early on in proceedings by non-parties. A non-party can always file a motion to intervene in abuse and neglect proceeding, and if that motion to intervene is denied by the circuit court, the party can then bring an appeal to this court, and this court can address it. So in this case, that's a grandparent. In W.Va and W.DC, which are currently pending before this court, those are foster parents, but the same theory applies with respect to who may bring an appeal. Moving on to the merits of this case, the circuit court properly denied intervention here. First, to answer the question on the timing, the home study was done by the department when they went to retrieve the child from the grandparent, where they thought the child was residing with the grandparent. They went to the grandmother's home and then conducted the home study at that time. However, thereafter, circumstances changed, and the department decided that grandmother was not an appropriate placement for the child. There are 5 places in the record where this is laid out. This court has requested the full record under Rule of Appellate Procedure 6B, and so I'll point to the court to the places in the record where the department made these averments. First, we have the October 17th court report from the department that was submitted to the court for purposes of the adjudicatory hearing that occurred on that day, and where grandmother was allowed to step into the courtroom, her counsel, and present argument on why she should have leave to intervene. The court laid out there that they believed that grandmother was not an appropriate placement because she was unable to protect the child from harm, either by mother or from other individuals. The department repeated this again in its November 20th court report, in its January 14th court report. In the January 17th case plan that was filed, the department again laid out why grandmother is not an appropriate placement. And then on January 29th in the court report, the department laid it out in the February 14th court report. There are numerous reasons that the department believes that grandmother is not an appropriate placement in this case. First, grandmother previously had custody of her other grandchildren. The department then removed those grandchildren from her care because they determined that she was not providing adequate care to those grandchildren. When the department came to remove the children, grandmother told the children to kick the department worker. So therefore, the department believed that was not appropriate. Twice in this proceeding, the department asked grandmother to tell them how they could contact mother. The department had trouble contacting mother, and that's why the preliminary hearing in this case was delayed, along with publication for the unknown father. And when the department asked grandmother to say how they could reach mother, she said she didn't know. But then a couple days later, all of a sudden, mother would call the department. The department therefore believed that grandmother was being untruthful about her knowledge of mother's location and how to get in touch with mother. So for at least 3 independent reasons, at the time that the circuit court denied the motion to intervene, it had the department's position as to why placement with grandmother was inappropriate.
How does grandmother, if she does not have the right to intervene, how does she contest those unrebutted findings by the department? How does she go about trying to enforce the preference stated in statute for her as a placement? The department has free shot at the judge or the fact finder, effectively, who is the judge in these cases. So how does grandma say, wait a minute, let me put on some evidence? How does she go about doing that if she's not allowed to intervene? This is a catch-22 case, in my mind, because she does not fit any of the categories. She's not, I guess, alleging that she was a caregiver or a custodian or a foster parent. She is one that is a prospective adoptive placement because she has a preference and has asked for that, apparently, to the department. But now the department has, in these private hearings, made these allegations against her. The judge has made a ruling based upon those allegations, and the grandparent has not had an opportunity to challenge those allegations. How is that due process?
First, Your Honor, let's be clear about the statutory framework. The statutory framework with respect to this issue changed on June 5th. On June 5th of this year, Code Section 49-4-601A took effect. Prior to the effective date of that statute on June 5th, there was no preference for placement with a grandparent prior to adoption. Section 114A3, the grandparent preference, only deals with once we get to adoption. 601A, the legislature has now determined that there is a preference for kinship placement with respect to all proceedings within 7 days of a removal, and there's a whole process for laying out who can get the preference for custody of a child early on in the proceedings. Second, Code Section 601H, which opposing counsel referenced, is a right to be heard. It's not a right to intervene. The right to be heard does not include the right to present evidence. Rather, it's just a right to go forth and present your position to the court. This court clarified that in State Ex Rel CH versus Faircloth, where it delineated when custodial foster parents have a right to intervene in a case. In State Ex Rel CH, this court explained that the right to be heard under 601H, even though foster parents have that right to be heard, that does not mean that they have the right to present evidence. And so even if grandmother was a custodian, she doesn't have that right. The citation for State Ex Rel CH is 240 West Virginia, 729. Key in CH is syllabus point 7. In syllabus point 7 of CH, this court held that even custodial foster parents do not have a right to intervene in proceedings early on in abuse and neglect cases. It's only when termination becomes imminent that then this court has held that custodial foster parents may intervene as of right. Prior to that time, this court has held that intervention under those circumstances is permissive in nature, and that the court should look to West Virginia Rule of Civil Procedure 24B with respect to the factors to consider when deciding whether to allow that intervention.
Can you point me to case law anywhere that defines what it means to have a meaningful right to be heard?
The CH again says that it does not include the right to present witnesses. Rather, it is the right to be present and to make the position known to the court through counsel.
So they have no right anywhere that you can find, and you can point me to, a grandparent would have no right to be in a position where they could counter the allegations made by the department in their monthly or periodic reports that they make to the court.
If they're a custodial grandparent, they would have that right once termination becomes imminent. And the reason, again, is set forth in syllabus point 7 of CH in the analysis that the court used in reaching that syllabus point. What the court determined was that custodial foster parents have unique factual knowledge that they can present to the court because the child is residing with them. And so therefore the court held that because of this unique factual knowledge, they should have the right to intervene so that they can put on that evidence. However, non-custodial foster parents don't have that. Non-custodial grandparents don't have that right. The grandparent can come forward at a later time and try to present evidence, for example, in a motion to intervene about why they are an appropriate placement. But the burden is on the grandparent and the counsel to know the circumstances. Counsel might not know that, prior grandchildren were removed from grandmother's care here, but grandmother knew that. And counsel may not know about the phone calls between the department and grandmother where grandmother was misleading to the department, but grandmother knew that. And if grandmother would have relayed that information to counsel, those circumstances could have been presented in the motion to intervene, and they could have also been presented when counsel was permitted to come into the courtroom and present her argument on the motion to intervene. But to allow any grandparent to intervene at any stage in the proceedings would lead down a dangerous path. The problem with that, again, is the new code section, which is 49-4-601A, because then you would be allowing that grandparents of both the father and the mother, and potentially any other kin in the first degree, including fictitious kin, are allowed to intervene as of right. That simply cannot be the case because it would disrupt the abuse and neglect proceedings, would potentially delay finality for the children, and could also lead to a loss of confidentiality.
Counsel, I know you clearly indicated that 601H relates to the ability to be heard, not intervene, but to the petitioner's suggestion that under the laundry list, under the opportunities to be heard, she indicated the grandmother fit the, quote, pre-adoptive parents category, and that was the one that she believes fit. Do you have any comments or about whether or not the grandmother would fit the definition of a, quote, pre-adoptive parent?
She's not a pre-adoptive parent. To be a pre-adoptive parent, you have to have custody of the child, and she does not have custody of the child in this case, so she does not fall under the definition of pre-adoptive parents. In closing, Your Honors.
Let me ask one question before you close. So, assuming we accept your argument on the operation of the statute, that the limitation on the right to be heard, as you've explained, based on the framework that you have outlined, what is a grandparent to do in terms of preserving or advocating in favor of the eventual adoption preference if intervention is not an option?
This court addressed that in Christopher O. v. Mazzoni, which is 227 West Virginia 184. In that case, this court held that when a foster parent was being denied the right to be heard and to seek placement, that they could file a petition for a writ of prohibition or petition for a writ of mandamus. Mr. Lampman explained that 13 days ago in his argument in BA as well, is that prohibition and mandamus are always available if the circuit court is not appropriately considering the grandparent for placement under 114A3 or 601A, and that the court could then grant that. Here in this case, we don't have that because the circuit court actually ordered the department to consider grandmother for placement, and the department did consider grandmother for placement and determined she was not an appropriate placement. Therefore, this court should intervene that the circuit court had the discretion on whether to grant intervention, and that the circuit court did not abuse that discretion in denying grandmother's motion to intervene, and should therefore affirm. Thank you.
Thank you. We could hear from the guardian, please.
That is our amazing court clerk who,
Very good idea. If it pleases the court, my name is Rebecca Mick. It's a pleasure to see all of you here today. I serve as guardian ad litem for the infant PF in this matter. First, I'd like to address a few points made by the petitioner in her presentation. She made reference to her motion to intervene in custody. Also in that motion was a motion to intervene in custody or, in the alternative, visitation. And the court, in the order under appeal, awarded the petitioner visitation. So the petitioner in this matter got what she asked for, because she asked for visitation in the alternative. Secondly, the petitioner implied that the department knows where they want to go with this case upon filing. I don't know what the practice is like in the petitioner's counsel's jurisdiction, but that is not at all the case in my jurisdiction. Logan County and all of the participants puts great emphasis on doing what the law requires, which is to first focus on unification. And a lot of resources and energy goes into doing that. So we do not pretend, as guardian ad litem, I do not start out knowing where the case is going. No one in the case does. Of course, as the case progresses, it becomes clearer. The petitioner references that a grandparent, because of the grandparent preference, is first in line for adoption. That's not the case. The grandparent is first in line for consideration. And I'll point out that in the order under appeal, the circuit court directed the department to do exactly that, was to consider it in light of the fact that the petitioner would be a possible preference grandparent. So he specifically ordered consideration, which is what the statute says. The statute says they're not first in line for adoption, they're first in line for consideration. Following a determination that the individual would be appropriate placement, then they're first in line for adoption. Okay, first of all, I agree with much of the state's argument with the exception of jurisdiction. I do not believe that the court has jurisdiction to hear this matter. In her notice of intent to appeal, the petitioner states the appeal is brought pursuant to Rule 54B of the Rules of Civil Procedure. This order under appeal is not a Rule 54B order. In no way does it express or imply that it finalizes the claims of the petitioner. In fact, the order appealed by its language does not finalize the claims of the participation of the petitioner. As mentioned, the DHHR was ordered to consider the grandparent for custody, making reference to the potential status of the grandparent preference. It is simply not a final order from the perspective of the petitioner. As a matter of fact, there was a subsequent order entered in this case regarding the claims of the petitioner. Within a couple days of filing the intent to appeal, a motion for consideration was filed. Now, I know that the petitioner claims she wasn't able to file that motion for reconsideration, but I looked at the docket of the file, and it clearly indicates that her motion for reconsideration was filed at or around the time it would have come into the court system. She did need to mail that, but she did, and it was filed. Okay, secondly, the matter is moot. Petitioner claims she had passed a home study. At one point, that was true. I do not believe if a home study was conducted this date that it would pass. The home study policy of DHHR requires that no home be approved for placement in the event a convicted felon resides in that home and the felony is of a certain nature that may involve a felony DUI. The petition...
Counsel, if I could ask you about that. I mean, if she has not had an opportunity, she's presented some evidence to us here, or at least an argument to us that the husband does not, or the grandfather does not reside in the home. So it seems to me there are a lot of different allegations that have been made in this case that there appears to not have been given, the grandmother has not been given an opportunity to respond to those.
Well, and today was the first day I had knowledge that the husband does not reside in that home, which surprises me, but nevertheless, I agree with you. It is a disputed fact.
So if you have that fact and the argument that the grandmother has never really, she wasn't a part of the other hearing, so she doesn't know what the basis of the denial of the right for placement or for adoption, shouldn't there be some mechanism for her to be able to have her day in court, so to speak, and be able to make her arguments on that?
Justice Armstead, I think she should, but as the law exists today, I don't think she has it. I think some mechanism would need to be provided by law. As you know, our abuse and neglect statutes are very, very complicated, very, very, very specific. They try to cover any and all situations that could arise. Our abuse and neglect statutes do not address the right to adoptive, by the way, this is an adoptive grandparent, it's not biological, to a right to an evidentiary hearing. The law requires the department to consider the grandparent preference. In this case, this particular grandparent was considered. Now, in large part, I know that because I serve as guardian ad litem. And every week I am privy to mounds of information regarding my clients, my children, the foster parents, the biological parents. I spend most of my time in interaction with people regarding cases. So I'm privy to a great deal of information that doesn't always make it into the record, but does guide my determination as to the best interest of the child. In this case, my belief as to the best interest of the child is that the grandmother, is that the grandmother not intervene. I do not believe that it is in the best interest of the child for my ward to be placed in the grandmother's home.
I believe your time's pretty much expired, so if you could bring your...
On the legal aspects, the legal merits of the petitioner's case, I agree with the state. So it would be redundant for me to repeat this here. And I've already covered my belief as guardian ad litem. Based on the information I was privy to, I do not believe it was in the best interest. I have set forth some of that information in my response brief. Some of it appeared in court reports, some of it did not.
All right. So no questions? Thank you very much.
Please remove your microphone. Thank you.
If there's any rebuttal from the petitioner.
Very quickly, I'll address the jurisdictional issue. I agree with what the state actually put on, that this court definitely has jurisdiction to hear a motion that denied an intervention in this matter. That is a final order as it pertains to my client. And just to give some clarification regarding the motion for reconsideration and some of the filing issues that we encountered, Logan County is an e-file county. In an e-file county, you cannot just make a notice of appearance and file a motion. When we didn't have e-file, that was real simple. You just send it over to the clerk's office and they accepted it. In e-file county, particularly in Logan County, I can't do it on the e-file system, which I'm very familiar with the e-file system. We have that in Putnam County where my primary practice is. So when I tried to send it to the clerk so that they could manually put it in, they refused to accept it. And after a couple days of kind of going back and forth with them and them having me call everything, even including the IT department, they finally said, send it directly to the judge, and then the judge can do an order. This was for our motion to intervene, to initially get in, my initial notice of appearance and motion to intervene. The judge will have to do an order allowing us to file this for you. So that's what I had to do, just to do a notice of appearance and motion to intervene. So when I went to do the motion for reconsideration, I ran into the same problem, obviously. And so I sent it to the judge, as I had previously been instructed to do. But I never received an order stating that it was actually filed. So here was the timeline. I have an order that was entered on January 7th, 2020 that I have to appeal by February 6th of 2020. I filed the motion for reconsideration, or attempted to file it, on February 3rd of 2020. By February 5th, 2 days later, I have no idea if this has been accepted and if it's actually filed in the case. If it had been, it would toll my statute for the appeal. But I didn't have that, and I couldn't let the statute for appeal run. So on February 5th, I filed the notice of intent to appeal. On February 21st, I received an order denying my motion for reconsideration. So I was like, oh, they did take it. That was denied. I perfected my appeal on March 9th. So we have a final order. The jurisdiction is proper in front of this court. The state referenced numerous times all of this evidence that got to the court through the court reports of the department. Well, number one, I don't have access to any of those reports, and as we have stated, had no opportunity to defend against those or to answer against those or to prove that those things were inaccurate in any way, shape, or form. And a number of the things that the Guardian brought up were just things that, again, we couldn't present evidence to the contrary. So I know the state and the Guardian pretty much state there's no mechanism for a grandparent to preserve or advocate for this grandparent preference. I'm asserting that I do think there's a mechanism, and that is through allowing a grandparent to intervene, to request for custody, and to receive an evidentiary hearing in regards to why they are not the best interest placement for the child. There's a presumption that the grandparent is in the best interest of the child. So that presumption has to be rebutted by the state and Guardian ad litem, and that has to be done through an evidentiary hearing. Nothing further.
If no further questions, this case will be submitted. Thank you very much.
Thank you.
Please rise. Remain standing.
We'll begin this afternoon's oral arguments with the Rule 19 argument docket. Everett Frazier, Commissioner of the West Virginia Division of Motor Vehicles versus Jerry Stire, docket number 19-0411, an appeal from the Circuit Court of Harrison County, West Virginia. And counsel, although Justice Workman is not here present in the courtroom today, she is viewing and listening via the webcast, and she will be participating in the decision and opinion in this case. And you will notice that we added a clock there to the left of the podium for you to keep track of your 10 minutes per side for oral arguments. With that, you may proceed.
Thank you so much. May it please the Court, I'm Assistant Attorney General Scott Johnson here on behalf of Everett Frazier, Commissioner of the Division of Motor Vehicles. I would ask to reserve 3 minutes of my time for rebuttal. Oh, thank you, Your Honor. In State Ex Rel State versus Gutsky, this court held that a police officer acting outside of his jurisdiction retains all the authority that a citizen would retain in that same circumstance. Commensurate with that recognition, it is obvious that a police officer does not shed his status as a citizen by donning the uniform of a police officer. In this particular case, it is obvious that a citizen acting in the same status as Officer Billy in this case would have in fact had the same authority to approach Mr. Stire on the evening in question. That constitutes a consensual encounter. That consensual encounter did not at all trigger the Fourth Amendment, because as this court held in the Ullman versus Miller case, in order for the Fourth Amendment to be triggered, there must be a seizure. A consensual encounter where one citizen simply approaches another citizen to ask about their health and welfare does not constitute a seizure, and therefore the Fourth Amendment is not implicated.
Does the citizen have the right to require the other citizen to perform field sobriety tests?
Your Honor, in this particular case, field sobriety tests were administered. They were administered voluntarily, and Mr. Stire submitted to those field sobriety tests.
I guess the question that I have, Mr. Johnson, is if a police officer comes up and asks for you to take field sobriety tests, if you refuse, what's the consequence?
Well, Your Honor, in this particular case, had there been a refusal, there would have been no consequence, and I will tell you why. Because on the evening in question, when Officer Billy approached Mr. Stire, he approached Mr. Stire after having already observed Mr. Stire stagger out of his car, stumble into the back of Mr. Stire's car, and stagger into the 7-Eleven. Officer Billy then followed, because he was concerned about what was occurring, followed Mr. Stire into the 7-Eleven and asked Mr. Stire how he was doing. At that point, he smelled alcohol on Mr. Stire and observed that Mr. Stire had bloodshot eyes. He then asked Mr. Stire if he had drunk and driven to the 7-Eleven, and the response was, "You didn't see me drive, you're out of your jurisdiction." At that point, Officer Billy observed Mr. Stire having slurred speech. Those factors in and of themselves constitute probable cause to believe that Mr. Stire was driving under the influence. And that being the case, the initial encounter that led to the arrest was proper and justifiable, regardless of the field sobriety tests. It was also reasonable.
On that issue that Justice Hutchins just raised, correct me if I'm wrong, but I believe in the Gutsky case, was there a field sobriety test performed in that case as well?
There was a field sobriety test that was performed. In the Gutsky case, the officer that was acting as a citizen pulled the driver over, and in that particular case, another officer that was within his jurisdiction performed the field sobriety tests. But again, my point is that Officer Billy, at the point where he initiated the contact with Mr. Stire and obtained all the information that any citizen could have obtained, would have had sufficient probable cause to effect an arrest. Additionally, there was probable cause to believe that Mr. Stire was driving. It's well-established law, and indeed was recognized by the circuit court below, that an officer does not have to observe driving in order to conclude that a driver drove under the influence. The fact of driving can be established by circumstantial evidence. And in this particular case, as testified to by Officer Billy, when he was at the 7-Eleven, or he had pulled into a subway driving lot, which was within his jurisdiction. Almost immediately next door was the parking lot to a 7-Eleven convenience store, which was out of his jurisdiction. He had been sitting there for about 5 minutes, and he heard a door open, and he observed Mr. Stire exiting from the driver's side of Mr. Stire's vehicle. There were no other occupants to the vehicle, and Officer Billy testified that he would have heard if any other driver drove up. The hearing examiner concluded that that was sufficient evidence to believe that driving had occurred. The hearing examiner made a specific finding to that effect, which was reversed by the circuit court. The circuit court violated an established tenet of administrative law, which is that a reviewing court cannot substitute its judgment for a finding of fact as made by the hearing examiner. So in this case, the arrest by Officer Billy was certainly within the purview of the Gutsky case. There was driving, there was intoxication, there was no problem with the arrest, and consequently DMV's revocation was in fact sustained by the record. The circuit court erred in reversing the DMV, or reversing the Office of Administrative Hearings in its decision to affirm the revocation.
Counsel, obviously in respondent's brief went to great efforts to distinguish Gutsky, give you an opportunity to address why you think Gutsky clearly applies, and you saw from the reply brief the distinction in that case where the actual erratic driving was visible, and the other things respondent suggests distinguishes. How do you think Gutsky actually does control here?
Gutsky clearly applies to this case, Your Honor. When a police officer is outside of his jurisdiction, he does not shed the authority of a citizen. Any citizen has the authority and the right, and I would submit to you as a responsible citizen the obligation under the facts of this case to approach the driver and say, "Are you okay?" And in this particular case, the fact that there was no observation of driving, as recognized by the circuit court itself, is really not relevant, because the underlying facts, as found by the hearing examiner, substantiated that there was in fact driving that occurred. But that leads to my second point. Even if we establish, even if the court would establish, and of course DMV takes the position that we proved driving, this was a dual revocation. There was also a revocation based upon a failure to submit to a secondary breath test. In this particular case, in order to submit to a secondary breath test, there has to be a lawful arrest. A lawful arrest is one that is supported by probable cause. The U.S. Supreme Court has explained that probable cause is not a particularly high threshold. It is, as the Supreme Court said in the Cayley versus U.S. case, not a high bar. And in fact, as the Supreme Court said in Gerstein versus Pugh, it's even lower than a preponderance of the evidence. And as this court specifically said in Reed versus Hill, the probable cause standard does not require that the officer's belief be more likely true than false. And in this particular case, based upon all the evidence that was adduced, Officer Billy had probable cause to believe that Mr. Stire was driving. Based upon that, Mr. Stire had the obligation to either submit to a secondary breath test or take the consequence of refusing to accept a secondary breath test and lose his license. No matter how the court slices it, DMV's revocation should be sustained as it is supported by the law and the facts of this case.
All right, thank you.
Thank you, Your Honor.
All right, can you take your microphone cover, please? Thank you. It's okay. I know it's hard to get used to it. So. Okay, you may proceed.
Thank you, Your Honor. My name is Tom Kupek. I'm representing Mr. Stire in this matter. And I thought it was interesting that a couple of the justices already noted what I think is very critical in this case. Gutsky is a good decision from any standpoint. The officer saw something very, very wrong, took action to stop it, and then called an officer who was in the jurisdiction to deal with it then. He did not go out guns a-blazing, trying to make the arrest, trying to do everything himself. He called it. In this particular case, Mr. Billy did not do any of that. First of all, just using the Gusky case, he didn't see anything that was a breach of the peace. With all due respect, in today's society, someone getting out of their car and bumping into the car and pawing at the air is not a breach of the peace. It may be something that someone would say, hey, you've got a problem, but it's not a breach of the peace. There was no justification for Officer Billy going up and confronting this man in the 7-Eleven. He did not have jurisdiction there. He knew he didn't have jurisdiction there. He knew that this man was going in there. He went in there. There was no disturbance inside. Now, if he was inside making a ruckus, if he was inside fighting with the clerk, then maybe it would be justified for him to come in and say something. But Gusky is totally different from this case. As a citizen of this state, I applaud the Gusky decision. I applaud the individual officer doing what he did. I have on my own occasion called 911 when I've seen someone driving erratically on the roads, on the interstate or somewhere else. And that's basically what he did. He just took it one little step further because he had the ability to do that. But in this case, there was no breach of the peace, no justification for Officer Billy to confront him. And no question, no reason for him to perform the sobriety test. The state police department, as is indicated in the record, the state police department is less than 200 feet away from where this occurred. He could have gotten a state trooper to come over easily, although it is 1 o'clock in the morning, but he was right there. There was no need of assistance, and then the state wants, the DMV wants to argue about the community caretaker thing. Well, this is so far removed from the Community Caretaker Act or statute or thing, whatever you want to call it, because first thing Officer Billy says was, were you drinking? His whole motive operandi was to try and get another DUI, which is another reason why I believe that the DMV was wrong in stopping the attorney from asking the officer about the previous DUIs. He was on a DUI run. It was his obligation in his life to find as many DUIs so he could move on to another career at a higher level than working for the city of Shinston. And there was numerous problems with that, as was indicated, and the officer, the hearing examiner refused to allow my son to look into those issues and stopped him from doing that. Further, the hearing examiner found the petitioner did state during post-arrest questioning that he had not been driving a motor vehicle earlier. And he also observed that he did not consume alcohol beverages earlier. So to say that there's no finding of that, that's exactly what came out of the hearing examiner's testament findings. Lastly, in regard to the introduction of evidence, there was no documentary evidence introduced into evidence in this case. Only one piece of paper was introduced. Now, the DMV goes out of their way to send out a memorandum and says, here's all the evidence we're going to introduce. And if you have any objection to it, you better know. And if we make a motion and you haven't objected, then it's going to be introduced. Nowhere was that evidence introduced. There's zero introduction into it.
Counsel, going back to your first point about the fact that, and I know there have been some questions about him performing a field sobriety test. In Gusky, though, wasn't more indicia of his role as an officer there? He had flashing, the red and blue lights on his car when he pulled him over, and so why are we really distinguished from Gusky in this case, where there was no pulling him over with a police car, or didn't it go even further in terms of indicia of a law enforcement officer in the Gusky case than what we have here?
Well, I think it goes this way, Your Honor. The reason the Gusky is distinguishable is, first of all, he observed an act that was a breach of the peace. He observed that without question. He observed that. Second, when he did that, maybe he went and used his police powers, if you will, by turning on the red lights and stopping this guy. But then what did he do? He stopped the guy, held them there. You know, this reminds me of the people in Walmart who think someone stole something. They don't have the right to arrest that guy. They have a right to hold him and contact an officer to come up and arrest him. And I think that's what Officer Billy would have had under his scenario. I don't believe that. I don't believe he saw him driving. His car was there for at least 5 to 6 minutes before he was there. It was there before he parked. He didn't see him drive. There's no indication he went up and felt the car to see if it was warm. There's no indication of what was going on, how he got there. There's none of that stuff. There's no keys in the ignition. There's nothing that would justify Billy saying he did it. But assuming that he did, then his duty is, as far as I'm concerned, would have been under Gusky, under any law, is to hold that man and say, look, you're going to wait here until we get a police officer who can deal with this, because I'm outside my jurisdiction. It's not my job to arrest you. It's not my job to perform the test. It's someone else's who has jurisdiction, and he didn't do that. And like I said, it was readily available to him, and that's not what he did. And I think that's exactly this distinguishment between Gusky.
Do you think there's any, I mean, the record seems to indicate that he believed that he had statewide authority, and whether he did or did not, that's one question, but do you think his belief in that case would justify him not going to the state police or getting another police officer in?
With all due respect, Your Honor, and I don't have the mask on so you can see me smile a little bit, okay? You don't know Officer Billy. Okay, Officer Billy was on a one-man wrecking crew to get as many DUIs as he had in the 6 months or 8 months that he was working. His sole function in life, as far as he was concerned, is to get as many DUIs under his belt so that he could move to another position, which he did do. But he's a nice person.
Is there anything in the record?
But so I don't believe. Beg your pardon?
Is there anything in the record as far as his motivation to do this or anything like that?
No, because the hearing examiner stopped my son when he started to question him about prior DUIs and his zeal for DUIs. And the hearing examiner said, no, we're not going to let you get into that, which I think, which really doesn't play into Gusky as much as it does to the community caretaker part of it, because it's obvious that he was not a community caretaker. He was trying to put another notch on his belt. And I like him. Officer Billy and I get along fine, and I'm not disparaging him, but that's the type of person that he was. And for him to make the statement that I thought I have jurisdiction everywhere wouldn't surprise me, but I know that he didn't believe it. We have jurisdictional laws. We have jurisdictions. He's a Shinston police officer. He's not even a county police officer. He was in Shinston police officer, and he was not in Shinston, and he knew that. The first words out of my client's mouth was, you're out of your jurisdiction. He didn't deny it. He knew it, and he should have acted accordingly under Gusky. Any further questions?
Okay, if not, thank you very much.
Thank you.
We'll brief for both.
It's a new reality here.
Mr. Kupek and I will figure out how this all works at the end of the argument. Just two quick responses, Your Honor. First of all, in order for one citizen to approach another citizen, there does not need to be any quantum of suspicion at all. As long as the individual question feels free to leave, there's no Fourth Amendment seizure, and the Fourth Amendment is not triggered. The concern that there has to be some type of suspicion to justify the contact is simply erroneous under the law. Second, even if Officer Billy was somehow mistaken in his belief, in the United States Supreme Court case of Heinen versus North Carolina, the U.S. Supreme Court said a reasonable mistake of law is not a violation of the Fourth Amendment. And in this particular case, nothing in Gusky says that an arrest is holding for someone else. In point of fact, if you read Gusky, Gusky says you can arrest as a citizen. And to Officer Billy, that's what he did. He arrested as a citizen. Your Honors, we would ask the court to affirm or to reverse the decision of the Circuit Court of Harrison County.
Go ahead.
Counsel, under Gutsky, again, reading from it says, off-duty police officers' warrantless arrest of suspected drunk driving officers' territorial jurisdiction was valid. Then it goes on, when officer observed arrestee's vehicle, it was being driven erratically and weaving. Again, it seems to me that Gutsky can be distinguished because the court specifically talked about the officers outside his jurisdiction when he observed this type of driving, and that didn't occur here.
That's true, Your Honor, but I think that that is merely an observational point rather than a dispositive one. In point of fact, the touchstone under the Fourth Amendment is reasonableness, and the question is, what was Officer Billy under these circumstances supposed to do? Was he supposed to allow Mr. Stire to return to his vehicle in an inebriated state and drive away and then stop him? That would have created more problems than it solved. And indeed, in this particular case, the circuit court even acknowledged that there's no observational requirement necessary for a police officer to conduct an arrest for DUI, and it cited a number of cases to that effect. The last point that I will bring up is that there's an argument that certain documents were not admitted. The DUI information sheet automatically comes in under Crouch, and this court has said that. So again, for those reasons, Your Honors, I would ask that the decision of the Circuit Court of Harrison County be reversed.
Let's assume, Mr. Johnson, that Gutsky gave Officer Billy the right to arrest based upon his observations. Probable cause is all that you need for an arrest, and it's a low standard. Smelled alcohol, glassy eyes, slurred speech. He arrests him. What gives a private citizen, because he was obviously acting as a private citizen outside his jurisdiction, what gives that private citizen the right then to go and demand field sobriety tests and secondary breath tests? Under what theory of Gutsky would this officer have had the right to then continue a, quote, citizen's arrest investigation to further his evidence to support his arrest? Under Gutsky, what theory does he have to do the field sobriety tests and then go require the secondary breath test?
Well, in this particular point, as far as the field sobriety tests went, Your Honor, those were voluntarily submitted to. But I would submit that if you read Gutsky, Gutsky then has to be read in light of a reasonable mistake of law. That in point of fact, Gutsky was an observational rather than a dispositive analysis. And if you read the statutes under which the officer functioned, it says law enforcement officer, which clearly Officer Billy was at that point.
Out of his jurisdiction, acting as a private citizen.
Your Honor, reasonable mistake of law, and I think that's DMV's position, is that what this constituted was a reasonable mistake of law.
All right.
Your Honors, thank you very much.
Thank you.
Thank you. This case will be submitted.
The next case for oral argument this afternoon is also under Rule 20, Mountaineer Fire and Rescue Equipment and Others versus the City National Bank of West Virginia and Joe Beam, docket number 180984, an appeal from the Circuit Court of Kanawha County, West Virginia. And counsel, although Justice Workman is not here in the courtroom this afternoon, she is viewing and listening to the oral argument through our webcast, and she will participate in the decision and opinion in this case. I'll remind you that each side has 10 minutes total to present the oral argument, and there is now a clock right to the left of the podium where you can keep track of your time. You're looking for it. It's right down next to your right hand on the table. Now it's next to your left hand. That's okay. You technically don't, but it's included in your 10 minutes, and so keep track of the time. You're welcome.
not a statewide, you're putting that on there. The court, we are far enough apart and have petitions here, so we've removed our masks to be able to ask questions. You may leave yours on or remove it as you wish during the time that you're presenting your argument.
I'm perfectly okay taking off. I had COVID earlier this year, and I'm through it. And I can say it wasn't as bad as I feared it might be, because I'm in that age group, close to 70, got some heart issues and bad back, but it wasn't that bad. It's like a bad flu.
Well, we're certainly glad you got
But I just make that disclosure so nobody has any reason to think I had withheld anything. It's just I'm over it.
And we're certainly glad you recovered.
Thank you. Well, good afternoon first. My name is Mike Wakel. I represent Mountaineer and the Cavenders in this case. And this case I'd asked for oral argument under 19 because there's just several issues that allow reversal in the sense that they filed a interpleader complaint, saying that they had $5,000 or so on deposit, which we had previously demanded they pay back, which prompted them to file this, their interpleader complaint, claiming an innocent party or an innocent stakeholder. And so I got the bank's counsel to give me what they call the account opening records. Each account, if you walk into a bank, you're going to fill out several papers to open an account. And then it's likely later the bank may come to you with additional papers because the federal government's always having, under the Patriot Act, they may want additional information because there's a lot of governmental concern about where money's coming from, who owns the deposit, the source, and everything. So they require these documents as part of it's a commercial banking procedure. And the document that's really at issue in this case, I'm getting a little ahead. First of all, they made a motion to dismiss, didn't identify it as a 12B6 motion, but I assumed it was. And they responded, their 12B6 motion took documents outside the pleadings, which should have required the court, because they made arguments, their principal arguments, well, not principal, but several arguments were made on documents submitted outside the pleadings, which we allowed, as we argued, the circuit court, that this needs to be converted to a Rule 56 motion, and we need to be able to complete discovery. We had served discovery, and then they filed the motion to stay. I responded to the motion to stay, which basically included a response to the motion to dismiss because they were kind of correlated, why the stay was not warranted, considering the motion to dismiss had been presented really with documents outside the pleadings that required the court to convert it to a motion for summary judgment. Well, we did not get any discovery except these few documents. Well, we submitted 36 requests for documents in the case, and we got responses, I believe, 4. So we were way short on the documents. But they filed that after we filed the response to the motion to stay. The court didn't really rule on any request to allow us for discovery. That was part of our relief requested to our response to the motion to stay. We requested documents, we'd be allowed to have discovery. We also asked, they're not required under 16B, that the court have the parties agree to a scheduling order and then submit it, which the rule actually reads the court shall issue the scheduling order. The court didn't issue the scheduling order, it didn't require the parties to issue a scheduling order. And so it basically ruled on a motion for summary judgment presented as a motion to dismiss and didn't allow discovery, didn't issue discovery, did not issue any discovery rulings or the scheduling.
Counsel, can I ask you, you say that the circuit court erred by failing to determine that City National was strictly liable under the UCC. However, I don't see that you've raised the UCC issue in your pleadings, and unless you can point to anywhere where you've amended your pleadings to include that, haven't you waived your UCC?
No, we presented as basically a defense to their motion, saying that there were these issues. It wasn't. I mean, I didn't put it initially. I looked at it as like pure contract. They didn't get the authority to open up the second account. They opened it anyway, and just UCC that makes every item out of that account not properly payable because the account was never authorized.
I'm trying to understand where in the pleadings you've set forth this, because you're obviously making the point here, but I'm trying to see.
It was a very minor issue as far as I'd put it in because I could not find
where did you? Sorry to be.
But where did you? Your Honor, and I should have anticipated you might ask this. I know it's in there, and I'll probably find it in just a second.
Well, maybe during rebuttal, if you're able to find it.
But it was a minor issue because when I was researching the issue, I determined West Virginia's never really looked at that issue of strict liability. But it has looked at it in a sense in the case that we cited.
Yeah. And respectfully, counsel, what I'm just looking for on the issue of waiver, I'm just looking for where in the pleadings you've set forth a claim relating to the UCC.
Okay, I know it's in there because I also discussed the APCOA case, which was another jurisdiction. That's the strict liability case. Although it may not be phrased, but it also references a case called Bradford Trust out of Texas. I think that was the first one where they started looking at, well, if we're going to have finality in the UCC, then we got to look at who was in the best position to stop the loss, prevent it. And our position is the bank, when they got the second documents to open the account and they weren't authorized by the members, it should have stopped right there. And then we wouldn't be here because our clients didn't authorize it as members. It required at least one of them to consent to it. It's a 3-member organization. And they never authorized it. They sent us the documents as that incomplete resolution was the controlling document for that account. We'd argued, well, it's no good because there's no authorization for it. It wasn't signed. They should have stopped it there. They did go back and inquire about certain other documents, but they didn't ask about the corporate resolution, which was really the most glaring of the issues because it didn't have signatures. They asked for things, incidental items like address that were included, but they didn't ask for the signatures. And that's really where they should have said, Mr. Beam, you've got to get this resolution. Well, then the bank, in responding to this, they based their argument on the contract, saying the contract authorizes Mr. Beam to do this without the signature of Mr. Cavender and without the member agreement. And the way they fashioned their argument is they took the resolution and they basically removed certain key provisions, pushed it together, and basically concocted the authority that they were trying to achieve. But under contract rules, you look at the entire document. And the first thing, when they basically said the document gave Mr. Beam the authority to go in and open up an account without anybody's signature authority other than his own. The basic resolution says they both have co-equal authority. He took that away in the second account.
Counsel, you only have a couple minutes left, so if you do want to reserve time, I just let you know that.
I'll just say that the contract's wrong. The way they interpret it, we provided a full. And if the court simply wants to look at that contract It is, they'll see, the authority they're claiming isn't in there. And thank you very much.
May it please the court. Ansel Ramey on behalf of City National Bank. Okay, what's proposed here would completely change both commercial and individual banking in the state of West Virginia. This and other courts have held banks have no responsibility to monitor a commercial checking account. That is incorporated in every commercial banking document that is executed, not just for my client, but throughout the state of West Virginia. Here's what this commercial banking document said, quote, any one of the authorized signers, Mr. Beam, Brian Cavender, quote, may enter into such agreements and perform such acts as they deem reasonably necessary, and those agreements will bind the company. And as its act indeed be, and they are hereby authorized and empowered to deliver and execute to the financial institution other account opening documents. So from the get-go, from day one, Brian Cavender and Joe Beam, on behalf of Mountaineer Fire, entered into an agreement, a contractual agreement with my client, in which they agreed that either one of them, Mr. Beam or Mr. Cavender, could come in and open a new account. It's in black and white. The contract also says, any one of such agents is authorized to endorse all checks, drafts, notes, and other items payable to or owned by this company, and to accept drafts and other items payable at the financial institution. The financial institution is directed to accept and pay without further inquiry. We're a bank. We're not a corporate babysitter. You're LLC. You need to watch your own. We're not going to do it for you. The agreements also said the authority hereby conferred on the above-named agents shall remain in full force and effect until written notice of any amendment or resolution thereof shall have been delivered to and received by the financial institution. Never got it. We got word there's a complaint. We assert there's some wrongdoing by another member. What do we do? Freeze the account and file an interpleader under the procedure established by this court. Finally, the agreements provide that the financial institution, my client, shall be indemnified and held harmless from any loss suffered of liability incurred by it to act in accordance with this resolution, the resolution that was signed by Joe Beam and Brian Cavender. 4 causes of action. None of them have anything to do with the UCC. Number 1, breach of contract. To this day, they've never identified a provision of the contract violated by my client. They didn't do it at the hearing. They didn't do it in their post-hearing briefs. They didn't do it in 2 briefs to this court. Never have they identified a provision of the contract violated by my client. Second cause of action, implied covenant of good faith and fair dealing. Well, this court in Highmark versus Jamie, one of my cases, said you can't have breach of the implied covenant without a breach of contract. There's no breach of contract here because they've never identified a provision of the contract breach. Here are their 3rd and 4th really creative causes of action. Aiding and abetting breach of fiduciary duty and aiding and abetting tortious interference. Okay, in terms of fiduciary duty, this court has held in Brozick versus Palmer, a bank owes no fiduciary duty to a depositor or a borrower because those relationships are grounded in contract. So we don't even know a fiduciary duty. How did we aid and abet by complying with a resolution signed by 2 members of the LLC to allow a new account to be opened? And by the way, as to that account, the original account was opened in 2011. New account was opened in 2013. All of the money in 2011 was put in the account in 2013. And guess what? Mr. Cavender cashed checks, got checks, went to the bank and filled out using the account number for cash withdrawals. And then in the counterclaim alleged, why I didn't know anything about it. On page, yes, Your Honor.
You attached all of that information to your reply, right? Or your answer to the cross-claim or counterclaim?
We attached it either to the motion to dismiss or the reply brief.
Right. And all of those documents are outside, essentially outside the 12B purview, aren't they? And so shouldn't the judge in this case have said, okay, we've got a bunch of documents here that have been attached that can be challenged or might be challenged or have some question about them, so we need to do discovery. And shouldn't he have converted it to a Rule 56 and allowed discovery in this case?
No, and here's why not. This court has held that when reviewing a motion to dismiss for failure to state a claim, a trial court should limit its consideration to 1, the factual allegations in the complaint, 2, documents attached to the complaint or incorporated to it by reference, 3, matters of which judicial notice shall be taken, and 4, documents that are integral to the complaint. And this and other courts have held repeatedly that in a breach of contract action, the contract, and I love the way the Fourth Circuit expressed it. The Fourth Circuit said if you sue for breach of contract plaintiff, the contract's on the table on a 12B6 motion.
Well, the contract may be integral, but what about all the other documents that challenge that plaintiff might have an opportunity to, or petitioner might have an opportunity or need an opportunity to seek discovery on?
The only other 2 categories of documents were also referenced in the counterclaims. Those are the checks, which there's no dispute. I mean, they're the images of the checks, and the monthly statements that went to Mountaineer Fire's address. And those are documents fairly incorporated. I mean, the Fourth Circuit said that otherwise a plaintiff with a legally deficient claim could survive a motion to dismiss by just not attaching the contract. It's the same with the checks and the monthly statements. And again, this gets back to, on a 12B6, I get a counterclaim on an interpleader. And the interpleader is basically a bank. I filed dozens of them for banks and insurance companies. We don't know who's right. We're not a court, right? We've got 2 members of the customer, the LLC, both accusing each other of misconduct. So what do? This court adopted, the rule of civil procedure. We file an interpleader. Here's the money. You guys fight it out. Bye-bye. We go. And then we get this counterclaim for breach of contract with no identification, breach of the covenant of good faith and fair dealing, which there isn't one, and tortious interference with fiduciary relationship or a business a contractual relationship. Well, you can't interfere with your own contract. We had a contract with Mountaineer Fire. We can't interfere with our own contract. And whatever contractual relationship Mr. Beam had with Mountaineer Fire, you can't interfere with that contract. Aiding and abetting, I mean, there just isn't any cause of action there. As to the UCC claim, I'll address that briefly and then answer any other questions. It's not in any pleadings, right? But what they refer to is a case called O'Mara Enterprises. And here were the circumstances. O'Mara's running a business. They have a bank, Ohio Bank, and they reach a deal. And the deal is when we pay our payroll taxes, right, the check will be made payable to the Ohio Bank. So O'Mara's employees made out checks payable to the Ohio Bank. Well, O'Mara's crooked controller on the back of the check stamps pay to another bank, and then $41,000 in checks are then deposited in that account. Why the Ohio Bank tellers cashed that, I have no idea. And so the court said, and so the bank raised this issue, well, O'Mara allowed a facsimile signature stamp to be used on the checks, and under the depository agreement, they authorized us to accept it, but this court correctly held, no, you don't get to that because of the UCC. Under the UCC, and the court held in Syllabus Point 1, the Uniform Commercial Code requires a check which is drawn paid to the order of must be properly endorsed by the named payee to be negotiable. And Syllabus Point 2, a restrictive endorsement that precedes the endorsement required by the named payee prevents the commercial instrument from being negotiable. You were just applying the UCC correctly. It has nothing to do with this case. They haven't challenged any of the checks. Joe Beam was authorized to sign the checks. Joe Beam signed the checks. In 1 month, I mean, that's why this contention is just so outrageous. In 1 month of 21 checks that were cashed, 11 of them were to Brian Cavender. And then in the reply brief, they say the bank was negligent because they let Mr. Beam open an account and use the same checks.
Counsel, you only have a couple minutes, so I don't know if your co-counsel was Point Speaker, if you want to use the rest of it and however you all
Well,
agree.
he's got another party, Mr. Beam, although I don't think that was briefed by the petitioners in the case, but I'll let him address that. Thank you, Your Honor.
Thank you.
Yeah, you.
She's good at it.
People will get used to it eventually, right? If we need to.
All right, thank you very much, Your Honors. Miles Berger with Romano and Associates here in Charleston, representing Joe Beam, a respondent in this case. Your Honors, there were 5 cross-claims asserted by Mountaineer Fire and the Cavenders against my client. Those were a breach of fiduciary duty, unlawful conversion of funds on deposit with City National, conversion of equipment owned by Mountaineer Fire, fraud, and tortious interference. And the Circuit Court, we believe, appropriately dismissed all of those claims on the 12b-6 because they failed to state a claim upon which relief may be granted. Very importantly, and you touched on this earlier, Justice Jenkins, when you were asking counsel for the petitioner about amendments and where in the pleading, the petitioners never filed a response to either the City National Bank or our motion to dismiss the cross-claim. They never filed a motion to amend their cross-claims, counterclaims, complaint, or whatnot to correct any number of the myriad of errors that were identified either at the Circuit Court hearing or in the pleadings or in correspondence between us beforehand, and they simply never moved the Circuit Court to do any of those things. So in the cross-claims against my client, the petitioners cited to non-existent code. I don't know of any other way to say it. I mean, code that just literally doesn't exist. And so no duties or anything can be held under a non-existent code, and I believe the Circuit Court therefore appropriately, stated the petitioners failed to state a claim upon which relief could be granted and dismissal was appropriate.
Well, it looks to me that they actually cited the wrong subparts in the right statute. And is that enough for notice pleading?
I believe that the Circuit Court did not think it was, Your Honor, and I believe that that is a relatively brief section of code. It wasn't clear to me or my client, or I would purport City National, what claims were being put forth throughout a lot of these counts and pleadings. It was a lot of incorporation of stuff and references to non-existent things, and just basically fraud was committed because you committed fraud. And that just doesn't rise to the level that this court and the West Virginia Rules of Civil Procedure mandate in the fraud case under Rule 9b. That was one of the other claims asserted against Mr. Beam, and the entirety of the paragraph just stated that, again, that he committed fraud. And I think it's clear from case law that that is insufficient so as to substantiate a fraud allegation, Your Honor. The tortious interference claim, which was the 5th, this court previously held in the Torbett versus Wheeling Dollar Savings and Trust Company case that so as to establish a prima facie case of tortious interference, the plaintiff or petitioner must show 4 elements. Number 1, the existence of a contractual or business relationship or expectancy. Number 2, the intentional act of interference by a party outside that relationship or expectancy. 3, proof that the interference caused the harm sustained. And 4, damages. In this case, as the Circuit Court found, the petitioner failed to allege the necessary elements, Your Honors, and that's why Judge King dismissed the counter and cross claims, we believe appropriately. And I just think, and we pointed this out in the hearing, and I think it's worth pointing out again, that the counsel for petitioner had a vast opportunity, numerous opportunities to amend his pleadings, to file responses to motions, and none of those were done. None of those acts were taken. None of those things were done, and my client would just ask that this honorable court please uphold the Circuit Court dismissal of the cross claims against him.
Thank you.
Thank you.
We have a brief rebuttal.
Our complaint had 86 separate factual allegations. They responded to 16 of them, 2 of which basically agreed, just said, okay, we assume that's true, but the rest of it, they just ignored and went off on this frolic and detour on these factual allegations from the documents submitted. We have a number of issues with the submission of the documents because they don't tell the whole story. And we'd explain that, but we did put in 68. Their argument, as far as Joe Beam's argument, first of all, the court adopted their orders as submitted. The court didn't appear the court did really any analysis. It just accepted verbatim their orders and assigned them. And their argument was you can't be liable under a law that doesn't exist, and that's what the court ruled. The law does exist. I just happened to miss it's a 6-sentence paragraph in the Uniform Code on Limited Liability Companies. And I got one of the subsections wrong, but it's basically, it says every member has a fiduciary duty of loyalty and care to the other members. And loyalty means you don't embezzle. And their argument was, well, you missed and we corrected that in our response. And they also just said, we did not respond to the motion to dismiss. Absolutely false. We incorporated our motion to dismiss response with our motion to stay, and then because they raised this silly argument, we asked the court, can we go ahead, after the hearing, submit a separate brief on the motion to dismiss, which we did. Basically, we just said, here are the arguments we incorporated in our response to the motion to stay, in which we touched on. Everything that City National is really arguing are factual arguments based on the complaint, with the exception of the contract argument. The contract argument is craftsmanship, in the sense that the contract doesn't say what he says it says. The contract says much more, but they pushed those provisions together and eliminated the controlling provisions. The idea that Joe Beam could go in, or my client could go in and sign any document, that was limited to account opening documents. And then the other thing they were allowed signal signatures on, where they could deposit, endorse, or they could write checks, either one of them. But it took 2 to open an account because that's the authority the board gave them. And if you read it the way he's asking the court to read it, then it totally obliterates 2 very important sections of the resolution. And one is, if it takes 2 to open an account without resolution, but they can't be contrary to this document. Well, when you make an account that takes out half the authority granted by the board and leaves it in one party, that's very contrary. And if you can't read that section compatibly with their argument, because their argument is basically one of concoction. If you take out words, you can craft anything. And if you look at it, I went through this entirely in my arguments, is that you have to read the entire document. If you read the entire document, it said the 2 of them could come in and open an account. Either one of them could sign account opening documents. Those are just the documents. Well, here's where it left off. The agreements will bind the company. And then they put ... And it says to carry out, what they left out was, or took out was, to carry out the provisions of the agreement of the financial institution. They're talking about that resolution. That's where they can sign it. Then it goes on, it says, acting on for behalf of the company, then you go ... and pick it up, and as it's act indeed be. But they left out, are hereby authorized and empowered to deliver and execute to the financial institution the limited liability resolution, that's what it's talking about. You have to bring us back this corporate resolution. And any other documents that we give you as the bank that we want you to complete. And that would be where the bank comes back and they have to comply with the Patriot Act, and they'll come back and ask for additional information. And either one of you can sign that.
You could kind of wrap it up.
All right, well, that's basically it. The contract argument is bogus because it doesn't argue the contract. The law does exist. That's ridiculous. 6A, they do have a fiduciary duty. And the idea that we didn't have a aiding and abetting, that's basically a factual argument because they're missing the facts relating to that are in these 88 financial or factual allegations they didn't respond to. And that's basically it. Thank you.
All right. Thank you very much. This case will be submitted. Thank you.
Thank you. Thank you.
Thank you.
Sir, Counsel, you have some papers left by on the chair.
Thanks.
The next case for oral argument is also under Rule 19. In re AB and AB, docket number 190718, an appeal from the Circuit Court of Logan County, West Virginia. And counsel, although Justice Workman isn't here in the courtroom this afternoon, she is participating through the website, viewing and listening to the oral argument, and she will be involved in the decision and opinion in this case. I'll remind you that this is a Rule 19 argument, so each side has 10 minutes of total time to split. There is a clock there to the left of the podium on the counsel table to help you manage your time. And with that, counsel for the petitioner may proceed, and counsel may either sit at the table, we have the chairs apart, or you may stay where you are. Thank you.
And I'll just let you know before you start, the justices have the plexiglass barriers between us, so we've taken off our masks to be able to ask questions. You may leave yours on or remove it while you're addressing the court, whichever way you wish.
May it please the court. Your Honor, we had brought this case before the Logan County Circuit Court on a modification proceeding. I'll get into a little bit into the details of the procedural history, but the court initially kicked this case back to the family court of Boone County at the conclusion of the abuse and neglect proceeding. At which time, the family court made a ruling which was proper that said that it, based on rules promulgated by this court, under Rule 6, it lacked jurisdiction to hear the family court case. At one point in time, it was somewhat of a question, at least in my line of work, as to whether once a case would be adjudicated or not adjudicated in the pre-adjudicatory agreement period, whether it would actually go back to the circuit court. This court has clarified on that issue, and it's very clear that the family court was proper in moving the case back to the circuit court. Now, at the conclusion of the abuse and neglect case here, what we had was a
case that was where despite some felony charges that were, to the best of my knowledge, have not been criminally charged. There was a major injury involving a child, an abuse neglect case was filed. There was a pre-adjudicatory improvement period that was allowed, contrary to the appellant's objection. At that point in time, what happened is we went through the abuse and neglect process on a pre-adjudicatory improvement period. At the conclusion of that pre-adjudicatory improvement period, my client had asked, because the children were placed within his care, the 11 and 13-year-old, the oldest of which is now 14, my client asked that the children remain in his care, and the reason for that was largely, from his perspective, based on what was a firm and reasonable preference. Now, at that point in time, the court went ahead and denied that and immediately placed the children back with the respondent mother. Now, at that point in time, what happened is the guardian ad litem made the court aware of the preferences of the children, but despite this, the case was dismissed. We filed in family court immediately for the procedural reasons I stated. That case was kicked back to the circuit court. Once it was back to the circuit court, we filed a petition for modification that alleged that the children have a firm and reasonable preference for residing with the children. And they had that firm and reasonable preference. It continued, and our allegation was that placement with the mother, primarily residing with the respondent, was causing the children emotional harm. Now, at that point in time, the court summarily dismissed our petition for modification. This was without the appointment of a guardian ad litem, and the court never heard anything new from the children, which as to why they primarily wanted to reside with with my client. That's the procedural history as to where we are. Now, the law on this is very, very clear. Certainly, the overriding consideration of the court is going to be the best interest of the child. But as part of that, there are certain things that need to happen for the court to make a proper determination as to what is in the best interest of the child. One of those things is the appointment of a guardian ad litem. It's important for the court to hear, in these cases, from a guardian ad litem, especially considering the history of this case, everything that had happened, and it was appropriate under the circumstances. The court did not do this. The court did not appoint a guardian ad litem. This court has made very, very clear that in terms of what standard should be applied in situations like this. The standard, and this goes back to the recent TM and SM case, largely we're supposed to apply Chapter 48 for any kind of modification proceedings that are going to happen, in particular when there's a pre-adjudicatory improvement period. While Rule 6 applies, and it does remain in the circuit court, at the same time, it's very clear based on this court's precedent that Chapter 48 is going to apply. And the court essentially disregarded that. They did not take into account Chapter 48, and it was improper for the court to do that, and that's why we are where we are right now.
Isn't this just a straight-up family court case that because there was a prior abuse and neglect case filed, and under Rule 6, the children were not returned to their cohabitating, the case wasn't dismissed, and the children returned to their cohabitating parents under Rule 6, it's got to stay with the circuit court.
That's
but
correct.
Isn't this nothing more than essentially a proceeding whereby your client seeks to modify the custody under the divorce order?
That's correct.
Okay.
Yes.
And so is it your position that you can bring in, because I'm a little confused at where you're headed here, is it your position that the fact that you can use the fact that an abuse and neglect case was filed as evidence of the need for a change or modification of custody? Is that your position?
Our position is that, I mean, that's part of our position, but it's largely that my client relied on, and he stated this from the beginning of the case, he wanted what his daughters wanted. That has been his consistent position.
Well, the daughters were under 14 years of age, right? And the statute says 14 years of age or older, the court's got to hear. Right. Under 14, the court may listen to them if he believes that they are sufficiently mature.
You are correct, Your Honor. This court has been clear, though, that certainly even under the age of 14, the court needs to look at the best interest of the children. We raised the issue of emotional harm, and we think that...
but your evidence is my kids want to stay.
The kids want to stay, and we had alleged they have emotional harm that's
related to what?
Well, just related to their current placement. That's essentially what we're arguing is they wanted to reside with their father we think that's really the basis for this. And since then, of course, one of the children is over the age of 14, and we had a modification that was denied despite that. But that's a separate issue. The court is correct that Chapter 48, that this is a family court proceeding, and family court rules are going to apply. If this were a case where, let's just say that this were a case where it wasn't quite to the level of filing an abuse and neglect case, but there was significant dangerous circumstances, that would have been, that would have been grounds for a modification.
Sure, but what we've got here is we've got an issue. We've got a case where there was evidence of problems, and obviously the children had to have been in imminent danger to be taken from their current placement, which was with the mother. And the mother was granted a pre-adjudicatory improvement period, and she complied and resolved according to what happened. The judge may obviously to dismiss it at the end of a pre-adjudicatory improvement period, had to make a finding that she had resolved the issues that created the necessity for filing the abuse and neglect case, right?
That's correct.
And so is it your position that you can use all of that and claim that it emotionally harmed the children even though mom fixed it?
Yes, Your Honor. Yes, that's correct.
Well, then why in the world would we not just leave it in the abuse and neglect proceeding and allow it to run through that process? Because if somebody goes through an abuse and neglect proceeding and repairs all the issues that were raised, and then we subsequently allow all of that evidence to be used against that parent in a modification hearing, what have we done?
Well, it's basically this. And I think that the circuit court raised a similar issue in terms of what they stated in the order. And the court basically said, well, we're really disincentivizing people from actually going and getting help and complying with improvement periods and so forth. And that's true on one level, but at the same time, the incentive for complying with an improvement period and doing what you're supposed to do is so your rights aren't terminated. That's what happens if you don't abide by an improvement period.
The number one outcome in abuse and neglect proceeding is reunification. The absolute last preferred outcome is termination. So you don't go through that process simply to not get terminated. No. You go through that process to reunify yourself with your children. I think that's the policy that the legislature has stated.
And I believe, if I could respond briefly, I think that it comes down to what we mean by reunification. I mean, if the court is saying reunification is everything goes back to the way it was, then yes. But we're not talking about reunification. Doesn't necessarily mean, and from my point of view, that everything goes back to exactly what it was before. Reunification could be a change of circumstances that results in a different parenting plan, and that happens all of the time in family court. So, thank you.
I'm sorry. Finish up your argument. I took a lot of your time.
Oh, that's fine. I think I'm just available for questions if anyone has any others.
All right. If not, thank you.
Thank you.
May it please the court. My name is Steve Thorne. I represent the...
You're going to have to speak up a little bit or get a little bit closer.
I'm Steve Thorne, and I represent the respondent in this case. This case was, as counsel just stated, an abuse neglect case. Where this case went wrong, I believe, for the petitioner in this case is when, at the conclusion of the abuse neglect case, that decision was for the children to be returned to the mother. That was the recommendation of the guardian ad litem. That was everyone's recommendation except for the petitioner. The guardian ad litem did say, probably you should wait till the end of the school year before you transfer, so it wouldn't disrupt their school. But the mother agreed to continue to transport him to the school, and so that the transfer was done immediately. That was March the 27th, we had that hearing, and it was entered on April the 4th, which was approximately 5 months after the petition was filed. That order was not appealed. So that became final. What petitioner did at that time was he filed an emergency petition based upon those same facts that had been argued in the abuse neglect case. And as he went through the procedure, we finally got to a hearing, looks like on July the 11th of 2019. Now, today, we are, next month will be 2 years since the initial case was filed, and there have been no issues with the mother at all. But at that hearing in July, based upon the emergency petition, the court basically said, as I understood his ruling, as follows, that you're now asking me to modify this parenting plan based upon a substantial change of circumstances. He then said, well, we were just here in March. What has transpired from March to now that was a change of circumstances? Because the ruling in March was that the children go back with mom. And we have resolved and taken care of all those issues that were alleged in the petition. And at that point, obviously the petitioner did not have anything as far as a substantial change of circumstances other than the allegation that the 13-year-old wanted to live with his father. Please understand that throughout this process, there were allegations that the father was coaching these children to live with him. I think it was even addressed by the guardian ad litem at one point. She's here today to discuss that issue. One of the issues, so the court said, I'm going to deny your motion based upon a substantial change of circumstances because nothing has transpired since my order. All those issues that we dealt with in the abuse neglect case are the same facts that you have alleged in this emergency petition. So he said it's no longer an emergency anyway, since it occurred in October of 2018. So then the petitioner argues you should have appointed a guardian ad litem. And the court responded and said, basically, we heard from the guardian ad litem at that final hearing in March. Since nothing has transpired that you can tell us that for a change of circumstances, there's no need for me to appoint another guardian ad litem. I've already heard from the guardian ad litem about all these facts. The petitioner referenced a case in his in his brief with regards, I'm sorry, it escapes me, but regards to I think an 11-year-old who could discuss, tell the court, not necessarily make a preference as to where they want to live, but give guidance to the court if they wanted more time. That case was a little different than this case because there was a 7-year difference from when the case was previously modified until that case. So the court said the children are a little older, they can at least state their opinion. That's different than what we have here. We only have a 4-month period. So the remaining argument is, and this is interesting, that the department was not noticed for the hearing. Well, the reason the department wasn't noticed for the hearing really was twofold. One, the petitioner filed this under, I guess, a Chapter 48 type petition, so he didn't notice them, number one. And number two, at the conclusion of the abuse and neglect petition, and I believe it's in the transcript at the very end, the CPS worker was there and basically asked her prosecutor to ask the court to excuse them from the hearing because this was going to be about parenting and the department didn't need to be there. And no one objected and they agreed. And so I think maybe that was part of his reasoning as to why he didn't notice the department. But
did the court at the final hearing to determine whether or not to dismiss the case at the end of the pre-adjudicatory improvement period, did the court hear these allegations that the custody of the children needed to be changed in their best interest because of this stated desire to reside with their father? Was that considered at that hearing, or was that information considered at that hearing? It was
argued by petitioner's counsel throughout the process that the children wanted to reside with the father. So to answer your question, it would be my belief that it was considered because he did make that argument at that hearing. But based upon the guardian's recommendation and the recommendation of the department, the children were returned to the mother.
Did the guardian address that child's preference, or was the guardian asked to make a determination as to whether or not the children were sufficiently mature to be able to express their opinions to the court?
Your Honor, I would ask that you ask that of the guardian because
that's a good pass.
I'm not really certain of that.
That's all right.
But I would like to say one last thing. Counsel mentioned the NRA TM case that has now given the courts, I believe, a little more direction on how these cases should end. You know, at the conclusion of it. But that case was published, I think, in November of 2019. Which is about 6 months after this case was over, at least the initial case. So based on all the above, the court had the discretion to not appoint a guardian ad litem. The court had the discretion to not hear from the child who was not age 14. And I think that the court made the right decision when the court said that there was no change of circumstances based upon the prior abuse and neglect case. So we'd ask the court to affirm the prior ruling.
All right, thank you. Can I hear from the guardian, please?
Your Honor, my name is Karen Hatfield. I was appointed guardian ad litem of the children in the underlying abuse and neglect case.
You want me to ask you that question? I mean, you handed it off. Did the court ask your opinion regarding what the position of the children were?
That question was asked to me, Your Honor. Throughout the duration of the case as guardian ad litem, the children presented to me with the desire to remain in the custody of the father to be able to play softball. That was the overriding desire to be in the custody of the father. The court has heard similar cases where there was a preference to be at a certain place because they had internet or they had cell phone reception, whereas the other parent didn't. But at no time during the underlying case did I feel that the children were in harm's way by being with the now respondent in this case.
Well, the question is, did the court in any way ask you to assess whether or not they were of sufficient maturity even though they were under the age of 14? Did the court ask you to assess that and give an opinion as to whether or not the court should hear from them, or did the court merely rely upon your representations regarding the reasons why they were saying that they wanted to stay with Dad?
Your Honor, I don't think I was ever asked directly to assess their maturity level. I was asked about the possible underlying reasons for their desire to remain in their father's custody. That's why, at the conclusion of the case, I recommended that they complete the school year where they resided with petitioner.
And then after that be transferred to the mother, and then the court, as I understand it, according to the record, the mother said, I'll take them to that school, and therefore the court sent them on back. Is that how it happened?
That's correct, Your Honor.
Okay, thanks.
Counsel, do you have any perspectives with regard to what appears, at least to me, that the circuit court relied on a primary caretaker standard, which may be the inappropriate standard instead of a best interest analysis?
The only thing that I can think of in that regard is that no time during the underlying abuse and neglect case was any motion filed by the current petitioner asking for custody of the children and asking that the standard under Chapter 48, 9606 through 609 be considered in making that determination.
Okay, thank you.
All right, if there are other questions, thank you.
Thank you.
I believe that
department's here, right?
Yeah, the department, sorry, we got a board there, and I apologize for that, so we'll ask that the department please come forward.
May it please the court, Melinda Dugas with the representing the West Virginia Department of Health and Human Resources today. The department took the position that the first two assignments of error that were before this court were not timely, as they were errors that arose from the final order of the abuse and neglect case, and that decision was never appealed. But with that said, we'll just briefly touch on those two issues since they've been discussed here. One of those issues was the court's decision to deny the modification based on the successful achievement the mother had during the course of her improvement period, and the other with respect to the reasonable preferences of the children. And the department would just assert to this court that those issues were raised on the March 27th, 2019 hearing, in the final hearing in this case. Whether or not they were sufficiently addressed is not necessarily clear from the record, but they were in fact raised. The department's main concern in this case is the procedural issue, is the modification issue. The department believes, based on this court's opinion in Ray TM, that the motion for modification should have been filed pursuant to Chapter 49. I believe this court said in Ray TM that with the exception of abuse and neglect cases which are dismissed for failure to state a claim, and those which are where the children are sent back to cohabitating parents, that the circuit court would retain jurisdiction, and that the provisions of Chapter 48 would apply to custodial determinations. I believe that that's not the case that we have here before us. This case was not a case that was dismissed for failure to state a claim. In this case, the mother entered into a pre-adjudicatory improvement period. Although it was prior to an adjudication, there was not any kind of a stipulation to the allegations of abuse, but they were evident from the record. the court made comment during the case that the mother had corrected her issues of fitness, and that was clear from the record. So in light of the syllabus point 3 of NRATM, I don't believe that that's the case we have before us today. And in that case, the motion for modification should have been filed pursuant to Chapter 49, Article 4, Section 606, with notice to the department and to the guardian ad litem. And then the fatal flaw for the motion in this case was that the department, neither the department nor the guardian ad litem had the opportunity to appear at that hearing and be heard.
Doesn't Chapter 49, isn't this, I guess, let me back up. Isn't this a Rule 6 issue and not a Chapter 49 or Chapter 48 issue? Essentially, the abuse and neglect case was over, right?
That's correct.
And so the parent went to family court, files under the original divorce proceeding, where they allocated custodial responsibility in the original divorce case, and asked for a modification of that order. The family court said, "Oh, wait a minute, there's been an intervening abuse and neglect case filed here, and under Rule 6, we can't hear it, so it's got to go to the circuit court." And I guess how long, my ultimate question is, how long does the department and the guardian ad litem get to stay involved in these kinds of cases whenever they have been dismissed under Chapter 49 and the child returned to the situation where that child existed immediately prior to the filing of that abuse and neglect case? How long does the department get to stay in it?
I understand your concern. It's my understanding from the law as it stands that there is no end date for the department's involvement in those cases beyond that, where the case was not dismissed for failure to state a claim.
Thank you.
Thank you.
All right. Any questions? Thank you.
I need a recording of that.
All right. If there's any brief rebuttal.
Just briefly, with response to the guardian ad litem and in reference to a motion being filed under Chapter 48, our position with that is we couldn't have filed that motion anyways during an abuse and neglect proceeding until such time as the abuse and neglect proceeding had concluded, the point at which there was actually a dismissal of the case. So we couldn't have filed any kind of motion then anyways. With regards to the issue, the procedural issue, keep in mind that the procedural standards for an abuse and neglect case are clear and convincing evidence. My understanding of that even applies for modifications versus a preponderance of the evidence under Chapter 48. So, I mean, procedurally, we believe that it was completely appropriate to file the motion, and as the Respondents' Counsel stated, that's my recollection too as to why the department wasn't involved. It was just kind of accepted that, well, once the abuse and neglect part of this case has concluded, the part at which the case is dismissed, the department was just not, it was just sort of accepted that that was going to be the case, that the department would not be involved at that point. And that's just where we went. So I just wanted to clarify on those points, and that's it.
Okay. All right. Any other questions? Court? If not,
thank you.
Thank you very much. This case will be submitted.
The final case for oral argument today, Lawyer Disciplinary Board versus McGinnis E. Hatfield, Jr., docket number 180101. And this is a case from the Lawyer Disciplinary Board. Counsel, I will let you know that although Justice Workman is not here in the courtroom this afternoon, she is participating by viewing the webcast and listening to the oral argument, and she will participate in the decision and opinion in this case. As you know, each side has 10 minutes to argue, and there is a clock down there to your left on the table to help keep track of your time. Thank you.
And to counsel, when you address the court, if you wish to remove your mask, you're welcome to do so. You may leave it on whichever way you prefer.
Mr. Chief Justice, and may it please the court, I'm Renee Freimeyer. I'm a lawyer disciplinary counsel for the West Virginia Lawyer Disciplinary Board. I'm here today on behalf of their decision rendered in Mr. Hatfield's case to annul his law license. Most of the facts of this lawyer disciplinary matter are not in dispute. Mr. Hatfield was recorded soliciting sex from a prospective client in exchange for his legal services. Following the hearing panel subcommittee of the board found that Mr. Hatfield's conduct had violated multiple rules of professional conduct and recommended that based upon the evidence and the Rule 3.16 factors, also known as the Jordan factors, that his law license should be annulled. This is a strong sanction which the board does not make lightly. However, it is consistent with case law of this state and others, as well as the ABA standards involving lawyers' sexual misconduct. This is also an important opportunity for this court to send a clear message to the bar and the public at large that there is absolutely no place for this type of behavior in the legal profession. It is not in dispute. Mr. Hatfield's voice recordings made clear that he only intended to represent the victim in this matter in her divorce if she would have sex with him. His intent was, and this is a direct quote from his testimony at the hearing, he wanted to trade his representation for sex with her. Mr. Hatfield made assumptions based upon his knowledge that this woman was an exotic dancer, that she would possibly be amenable to this type of arrangement, and used his position as a lawyer to further that goal. It's extremely egregious behavior on the part of a lawyer, and he preyed upon the victim, which she made clear in her testimony at the hearing, made her feel like a prostitute. She rejected these advances. She was strong enough to not be pressured into this unwanted relationship, but it's clear that this conduct was still egregious and cannot be tolerated from an officer of this court. The sanction...
Counsel, in the issue of, obviously this court has strived hard to be consistent in upholding the discipline recommendations based on prior decisions. What role did the lack of acknowledgement of this attorney to his behavior play in the ultimate decision to annul versus suspend?
It was definitely one, it was an aggravating factor, one of many. There were 5 aggravating factors that the board found in this case and no mitigating factors. The case that is guiding for the board that was cited in their recommendation was the Stanton case from 2014, which was a 3-year suspension for pursuing a relationship with incarcerated female clients. It was also, he was found to have a predator relationship with these women, similar to the case at hand, and also preyed on vulnerable clients who were incarcerated. In this case, this client was vulnerable. She was in a highly emotional place, being just served with divorce papers. She did not have the money to retain a lawyer. Mr. Hatfield was well aware of that fact, and so she was a vulnerable client. And so Mr. Stanton's case, that was a 3-year suspension, and the board did find that his failure to acknowledge the severity of his conduct, his repeated claims of no remorse for his conduct, and in fact setting himself up as a victim of this woman when there's no evidence in the record that she ever attempted to use this information she had recorded in any way but to report him to the proper authorities. And they found that that was that called into question his overall fitness to practice law.
The other question I have is relating to the 3 prior admonishments. What did those involve, and were those aggravating factors?
They were aggravating factors, even though Mr. Hatfield has been a member of the West Virginia Bar for 45 years, so they were, the board's decision didn't focus on those prior admonishments. They mentioned them, that he had those in his record. I can grab my brief, they were summarized. The prior admonishments were, one involved behavior towards his former wife in a divorce proceeding. I think he kind of shoved her during a court when they were passing each other in court, and the investigative panel found that that was inappropriate behavior on the part of an attorney. And the other 2 are discussed, and I can look at that now or in my rebuttal. But they took place. Usually if the admonishments took place over 5 years, then they're not, and it's not, similar behavior. They did not involve sexual misconduct with a client or any similar claims. They were admonishments for different rules of professional conduct, none that he was charged with or found guilty of in this case. So it was included as an aggravating factor for prior discipline, but not, I don't believe that was the major aggravating factor that strengthened the sanction in this case. Just want to point out just the fact that this sanction for this behavior the board did find that it amounted to a criminal act. The recordings show clearly that soliciting the victim into committing an act of prostitution was in violation of the law, and that was also a factor that took this from maybe a suspension type case but to an annulment, because that the public policy of behavior on the part of a lawyer that is illegal conduct has no place in the practice, and again called into question his overall fitness. And I can discuss some of the other cases, or just the fact that Mr. Hatfield has not met his burden to show that the findings of the hearing panel are not supported by the evidence or the record, and this court should adopt their recommendation. It would serve the primary goals of our process in this court, which is to reassure the citizens of this state as to the integrity of our attorneys, and also be important in deterring other attorneys from considering this type of behavior, and bring justice to the victim in this case as well, who has done nothing but report this conduct, and she just wants him to be held responsible for the way she was treated.
All right, thank you.
Mr. Chief Justice, honorable members of the court, I'm John Fuchenberger. I'm representing Respondent Mac Hatfield, and here to argue in his behalf against the recommendations of the subcommittee of the Lawyer Disciplinary Committee. As Ms. Reimeyer says, the The factual allegations here are not contested. The court has a very complete record in front of it. It has recordings of the telephone conversations, and I would encourage you or your researchers to listen to those, to listen to the tone of the conversations. What is contested is the conclusions that the subcommittee drew from the evidence after a very lengthy period of consideration, and came down with the recommendations. Because we believe that the conclusions of the subcommittee are overstated. They completely overlook the fact that the complainant said things in her sworn testimony and in her sworn complaint that were not true. She claimed, for example, that Mr. Hatfield had called her 60 times over a period of 60 times a day. She claimed that he continued after she filed this complaint to contact her. She claimed that he came to her apartment and left a card on her door. These are in her sworn statement. But then when there was actually the hearing before the subcommittee, she did not come forward with any of those claims. And so what we have before us, what this honorable court has in the record before us, is 17 minutes of conversation. There were a total of 36 telephone calls. There was never an in-person meeting between these parties. In fact, how they had met was at a strip club. The respondent had met the complainant at a strip club where she was a lap dancer. He had paid her money for her services, and not to be coarse, justices, but the lap dance is where the participants, the person who's paying for the dance, sits completely clothed.
Counsel, setting aside what you were describing, let's just take the 17 minutes, and I've looked at the transcript from that call, and let's focus just on the call. Very well, Your Honor. In and of itself, do you think, or does your client believe that there is any violation of the code of conduct? Because it seems to me that it's his position that even just that there's not a violation of his responsibilities. And that's part of the aggravating factors, is that there appears to be no remorse, no even acknowledgement that his oral conversation of soliciting sex for the representation was a violation.
Mr. Justice Jenkins, I believe that the end of the transcript shows that Mr. Hatfield did express remorse for his conduct and suggested that he should be reprimanded for his conduct.
Well, maybe that's the part. That's the next part. What, based on the case law and the decisions, what does your client believe the appropriate sanction would be?
Reprimand, Your Honor.
And that's based upon his claim that the only thing he engaged in was coarse language?
Yes, Your Honor. And I believe that's what...
And he does not believe, and just to make sure, he does not believe that the transcripts that I've read of those 17 minutes constitute a violation of any of the code of conduct related to solicitation of sexual favors in return for legal representation. He doesn't believe that occurred.
Mr. Justice Hutchinson, let me give a bifurcated answer to that, if I might.
Well, first, bifurcated answers. I just love them.
Beg your pardon, Your Honor. But,
no, go ahead.
First of all, he does admit that his conduct is reprehensible, and as I say, welcomes and suggests that he be reprimanded for it. But on the second, if you look at the conduct, what the rules prescribe, Rule 7.3 prescribes direct contact with a prospective client, and you can't solicit for any involving of coercion, duress, or harassment. And there's obviously no coercion, obviously no duress. This is on the telephone. These parties never met each other except at the strip club and at a restaurant before this attempted representation. And harassment, the complainant called him 16 times, Your Honor. He called her 18 times, she called him back 16 times, and I don't think you could come to harassment. In other words, keep responding to calls again and again and again until you get on tape what it is that you're trying to get down, and then you quit. At no time in any of those tapes did you say, I refuse your contact. I tell you to desist in this contact. Don't call me again. That never happens. And so I don't think that could be conceived as harassment. And secondly,
Rule 8.4 says, as far as under misconduct, there were two sections that the subcommittee found Mr. Hatfield guilty of. First, to commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness. And I don't defend the behavior. It's not criminal. The parties met at a strip club. No one suggests that was an act of prostitution, when in fact sexual favors were exchanged for money. And so this is an opening. He also suggested he would take her out to dinner. He suggested he'd give her some money, irrespective of representation. And so the words are just, the requirements of the rules are just not made out, Mr. Justice Hutchison. And again, the disbarment standard that the Disciplinary Council quoted talked about...
Let me go back to, just before you shift, I'm sorry to interrupt you as you transition to another point, but I just want to make sure I understand your argument. Your argument is that when a woman asks for representation and the lawyer says, well, if you have sex with me, I'll represent you, that is not a violation of the rules.
No, Your Honor, I'm not saying that.
Okay, so I misunderstood.
Yeah. It's a violation of the rules. I don't think it's a violation of the two rules that they are decided by the subcommittee, and for the reason that the language of the rules just does not apply. Now, when we get back to the annulment standards that the Disciplinary Council quoted, that says that it's a conjunctive standard that has to cause injury to the complainant. Now, the only evidence of injury was the unsupported testimony of the complainant that she was made to feel bad and worthless and had to have psychological testimony. This court hears cases where psychological testimony, workers' compensation, and personal injury cases require expert corroborative testimony. None of that here. And further, the complainant herself, her actions in continuing to come back and back and back to Mr. Hatfield do not indicate any fear, knowledge of coercion, resentment of harassment, and that is just not made out either, the standard. So in Mr. Hatfield's position, this entire thing is that the hearing subcommittee has overstated the charges against him and overstated the penalty that he risks by the conduct. If the honorables have no more questions,
Any further questions?
No, I have nothing further.
No? Thank you. There's rebuttal from petitioner.
At its most basic definition, prostitution is the exchange of a sexual act for compensation. And the hearing panel subcommittee was clearly in their rights to determine that what Mr. Hatfield, the conduct that he did, that amounted to solicitation of prostitution, and found that he violated that rule regarding illegal conduct. The panel heard from the victim. They found her and her damages she testified to as far as the emotional effect this had on her real and credible. She was very seriously upset about the incident, even though her testimony had been years after it had taken place based upon circumstances out of her control. Mr. Hatfield, this case was delayed some time due to an injury Mr. Hatfield has suffered.
What about, counsel, but what about Mr. Fuchsenberger's argument that she called him 16 times and he called her 18 times, as though they had an ongoing negotiation? How can that substantiate harm?
Well, she had just been served with divorce papers. She knew Mr. Hatfield was a lawyer. Presumably, he gave her his number to call her if she needed a lawyer, which she did. And so she was seeking out a lawyer. She's on record on the recording saying, well, I thought I was going to pay you. Why can't I make payments? And Mr. Hatfield clearly is like, no, I don't want payments. I don't want money. I just want sex. And if you can't do that, then you're going to have to go somewhere else. And I believe she probably made the repeated, she didn't testify to this, so it's not in the record, but one can, she was recording him at some point because she wanted to report his behavior to the authorities or to the proper offices, and I knew that he said, she said in this scenario doesn't have a whole lot of evidentiary value, as much more than a recording does. And there's no evidence that she ever intended to use the recording for anything else than to report it to the proper authorities. She never once asked for any type of money, or other financial assistance from Mr. Hatfield. She just needed a lawyer in her divorce. And, Mr. Hatfield said throughout the proceedings several times that the recordings spoke for themselves, and what they speak for is behavior that has no place in our profession and must be sanctioned accordingly. This sanction must be very instructive to the public, that conduct will be have a strong sanction, and that is also, aside from the emotional damages that the victim suffered, there is that level of damage to the integrity of our profession and the public confidence of our profession as a result of this type of behavior. Thanks.
Anything further? If not, thank you very much. This case will be submitted.